All right, good morning, everybody.
Morning.
Good morning, Your Honor.
Back on the record, state the floor with Herbert Swilley, 23 CS 4461. I believe we have verified that the juror who was removed was Mark Cole. Is that correct?
Correct.
Does anyone want any additional verification of that?
No, Your Honor.
Okay. Normally what I do is, the first thing I do when I'm getting ready to move the jury back is identify the alternates anyways. So if I call a name and another person gets up, let me know and I'll correct that. But otherwise, everyone is ready to go. Is that correct?
Yes, Your Honor.
All right. Mr. Swilley, you've been given an opportunity to call all the witnesses you want in this case. Is that correct?
Yes, sir.
There's no other additional witnesses you can think about that you haven't called?
Yes, sir.
Okay. You're satisfied with your attorney services to you thus far?
Yes, sir.
All right. So what we'll do is we'll bring the jurors in. I'll ask them the same few questions I typically ask them. Are you going to need, what do you need for closing?
Just access to the screen, Your Honor, that's all.
Okay. So many places we could put the podium these days, but you want the podium in the orientation it's at?
Yes, Judge, I don't need the podium. That's fine.
Yeah, it used to be we'd move it out of the way, but it's immovable.
Okay.
But if you want to point in one way or another, that's the sole extent of what I can do these days on a podium. It's wired to the floor. So I'll read up to, it's really not even very long. Go through the charges and then read closing argument. Okay, so, I mean, I don't think it has to be said because everyone's been very good in this case, but anyone in the audience, please do not say a thing during the trial. Everyone needs to remain quiet. I know everyone has done so far, and I appreciate that, but it's very important at this stage, we're at the very last stage of the trial. I don't want anyone to do or say anything that could throw us off. So I'm telling you now, if you say or do something during the trial, I'm going to stop the trial and conduct a hearing regarding contempt. So please do not say anything out loud or anything like that, okay? So everyone's been very good so far, and I appreciate it. The parties appreciate it, but I don't want to blow it at the end, okay? Let's bring the jurors in, please. Also, everyone make sure the phone is off or silent. Okay, thank you. Morning, everybody. As I always do before we go forward, I'm just going to ask by show of hands, has anyone said anything to you about this case? I see no hands, and I appreciate it. Have any of you talked to anyone else about this case? I see no hands, and I appreciate it. Has any of you gone online and looked up anything about this case? Again, I see no hands, and I do appreciate it. As I explained to you yesterday, I'm going to read to you first the initial part of the instructions. All of what I give you, you're going to get copies of, but I ask you to pay close attention to it as I read it, okay? And then we're going to have the parties do their closing arguments, and then we'll give you the last instructions. I anticipate you will get the case sometime before lunch, okay? We have your lunch ordered. You're free to eat lunch and deliberate. You're free to eat lunch and then deliberate after. You do whatever you want to do. Once we put you in the deliberation room, it's up to you, okay? But if you can listen carefully to me. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Herbert Swilley, the defendant in this case, has been accused of the crime of first-degree murder. Homicide. In this case, Herbert Swilley is accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Timothy Smith was killed by Herbert Swilley, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, second-degree murder, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the three following circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act, by lawful means, with usual ordinary caution, and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Herbert Swilley may be found guilty of first-degree murder or any lesser crime. Count 1, this is the only count, murder, first degree. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Timothy Smith is dead. 2, the death was caused by the criminal act of Herbert Swilley. 3, there was a premeditated killing of Timothy Smith. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. Murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Timothy Smith is dead. 2, the death was caused by the criminal act of Herbert Swilley. 3, there was an unlawful killing of Timothy Smith by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Timothy Smith is dead. 2, Herbert Swilley intentionally committed an act or acts that caused the death of Timothy Smith. Every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, then that violation, I'm going to reread that. Every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either a justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment, through each stage of the trial, reread that. The presumption stays with the defendant as to each material allegation in the indictment, through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Both the state and the defendant have now rested their case. The attorneys now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Ms. Burnt, are you ready to proceed?
Yes, Your Honor, may it please the court? May I have access to the screen?
Yes, ma'am. Right now, there's nothing plugged in.
Thank you.
You're welcome.
Good morning, members of the jury. Before I start, I want to thank you for your time and attention this week. I know it's been a long week, and there's been quite a bit of evidence and a lot of witnesses, so thank you for that. This is Tim Smith. Tim was happy. He was successful. He was kind. He was involved in the community. And he was loved by everyone. Tim was everything that the defendant was not. And the defendant couldn't stand it. And when Tim decided he was finally going to leave the defendant and move to DeLand and get a new job, the defendant was so angry. He told everybody, if Tim thinks he's leaving me and moving, he's got another thing coming. He thought Tim owed him. He was not going to let Tim leave him that way. So instead, he brutally murdered him. This is a case about death by 1,000 cuts. And what that means is that there isn't one big piece of evidence or one big witness, but the accumulation of many seemingly small pieces of evidence, when put together, become devastating, and they result in the overwhelming proof of guilt. That's what this case is about. The defendant thought he was smarter than everyone. When Darrell Levine asked him, "Did you do this?" he didn't say no. He said, "No one is ever going to be able to prove it." But guess what? He hadn't met Sergeant Pinder and the other detectives from the Marion County Sheriff's Office, because they worked tirelessly for 8 months to prove this case. And remember all the things they told you they did. The detectives canvassed both neighborhoods where the apartment was and the residence was numerous times. They dug through the trash at those places. They knocked on every door and tried to collect every piece of video that they could. Other detectives went to every single business on the street between the apartment and the residence. They dug through the dumpsters there looking for evidence. And they got every single piece of video footage that they could. And then for the next several months, Sergeant Pinder reviewed all of that video footage. And think about how much video footage that was. I mean, they were asking for a span of 12 to 24 hours. He reviewed every piece of that until he found the defendant's truck and Tim's Jeep on that. So in the end, the defendant was wrong. We can prove it to you, and I'm going to show you that this morning. The defendant's charged, as you know, with one count of first-degree murder. And the judge read this to you, and this is in your jury instructions. This is what we have to prove to you before you can find the defendant guilty of first-degree murder. Now, you also heard in the jury instructions, there's what's called lesser included offenses. So even though this is what's charged, you will have two other options: second-degree murder and manslaughter. But the judge will tell you, you have to find the defendant guilty of the highest charge we have proven to you, which I submit to you is first-degree premeditated murder. The elements of second-degree murder and manslaughter are in your jury instructions. Second-degree murder would be if there was no premeditation, and the defendant and Tim just had a big fight, and the defendant killed him. Manslaughter is if the defendant didn't intend to kill Tim, but he did an act which killed Tim. Neither one of those apply to the facts in this case. And when you look at the elements of first-degree murder, you won't need to go any further to even look at the second-degree murder or the manslaughter. Now, as you see, there's three things, and that's it. These are the three things that we have to prove to you for you to find the defendant guilty. Number one, Timothy Smith is dead. There's no question there. That was stipulated to. That is Timothy Smith, and he is dead. The defense is stipulated to that. Number one is crossed off. That's proven beyond a reasonable doubt. And I want to skip to three, the premeditated killing of Tim. Was it premeditated? And I think a lot of people have the wrong conception of what premeditated means. This is the definition of killing with premeditation. It's killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. And what this means is there is no amount of time that has to be present. It doesn't have to be an hour before he decided he was going to kill Tim, the day before, or the week before. The only thing that has to happen for it to be premeditated is he decided he was going to kill him, and he had time to reflect on it and do it. That's what this says. There is no fixed exact period of time. That is what the law in Florida is, for you to find him guilty of premeditated murder. And I know we see a lot of shows on TV, and they make lists, they plan it for a while. And even though he did do that here, there is no set amount of time for premeditation. And how do we know it was premeditated? We have two different ways we know. One is the diphenhydramine. Tim did not take the diphenhydramine. The only way he got the diphenhydramine was from this guy right here. He had 30 times the amount of a normal dose of diphenhydramine in his system. We know he had a big interview the next day. There's no way he took that on his own. And he's the only person that could have given it to him. And the only reason that he would do that is so it would be easier for him to kill Tim, and Tim couldn't fight back. And that's why he did that. That's the only reason he would give him the diphenhydramine. And that clearly proves premeditation. But even if you don't think that he gave him the diphenhydramine, or you have questions about that, The manner in which he killed Tim proves premeditation. And that's because of a strangulation. That's a prolonged, tightening, squeezing, remember, until he broke his neck. When you are doing that, it takes some time. And Dr. Corey said that mark was so defined and dark that it had been on there a while. During that time when you are doing that and you are squeezing, you intend to kill Tim Smith. There's no way you don't intend to kill Tim Smith during the time it takes to strangle him. That is premeditation. Fits the exact definition of premeditation. And also, it's not just strangulation. We have two separate acts. He not only strangled him in the most horrific manner, he beat him in the face. I mean, multiple blows, multiple. You have the left eye, you have the right eye. I mean, during that time frame of beating him in the face, the time it takes to go get the ligature, whatever it was, maybe he had it next to him. He had to consciously pick that up, put it around Tim's neck, and then start squeezing it. There is no way you can say that he did not intend to kill Tim Smith and it wasn't premeditated. For both of those reasons. This is clearly a case of premeditated murder. He didn't just all of a sudden snap and say, oh, I'm going to kill Tim. And that's 3. So now we've met 1, Tim is dead, we've proven that beyond a reasonable doubt. Is it premeditated? Sure. You have 2 different ways it's premeditated. Pick which one. They both apply in this case. What does that leave? The death was caused by the criminal act of Herbert Swilley. That's the last thing we have to prove to you, is that this guy did it. I first want to talk about the defense witnesses before we go into our evidence. We heard from Amy Counts. She said she heard a child or a person screaming Friday night in the general direction of the apartment of Tim and the defendant's apartment, which is 3.5 blocks away. Thanks for the testimony, Ms. Counts, but Tim was already dead at that point. We know Tim was dead Friday evening, around 11 o'clock. Remember that there had been no use of his phone after 9:45 on Thursday. He didn't go to work, nobody had seen him, he didn't reply to a text, he didn't reply to a call. And by the time they found him Saturday, he had already started to decompose. So, Amy may have heard some screaming or a child screaming Friday night, but it didn't have a thing to do with this case. Not a thing. And it added nothing. Matt Beeler, I'm not really sure what he was called for. He said he flirted with Tim on Grindr the week he was killed, and then he found out Tim died. Okay. So that's fine, that's all true. That doesn't affect anything, the facts of this case, or make the defendant not guilty. Danielle Velez went out to smoke Thursday night around 9 p.m. The Jeep wasn't there. That's true. It wasn't there at the time, 9 o'clock, because it was at the house. She went to work Friday morning, and the Jeep was there. And she thought that was unusual because it usually wasn't there overnight. True, that's true, we proved that ourselves. The Jeep went there late Thursday night into Friday morning after 9, and then it was still there Friday morning because Tim was dead. So Danielle Velez helped prove our case and reinforce what we've already told you. And now we have Rebecca True. She was married to James True. He seems like a horrible individual, and I feel sorry for Rebecca True. But Rebecca True also helped prove our case that James True didn't do it because he was in Fort Lauderdale at the time, which we proved to you. How? James True. So if you remember, we had heard a lot about DNA. James True's DNA was on an adult sex toy. And if you recall, also, defendants and Tim's DNA was both on that adult sex toy as well. The majority of the DNA on that sex toy was the defendant's. We don't know who had sex with James True at the apartment. That is unknown. All of their DNA was on the sex toy. They both used the apartment for sexual activity. And if you recall, in Deputy Hunt's body cam, the defendant told Deputy Hunt I was here last Saturday with someone. Tim did not want to play, so he went on a motorcycle ride. So the defendant was there 1 week prior. And that body cam is in evidence if you need to watch it. James True's fingerprint was also on the gun oil lubricant bottle in the bedroom. He was clearly there. He had sex with someone. But what do we know? James True was in Fort Lauderdale where he lived from 5 p.m. on Thursday, March 23rd, until Friday, March 24th at 9:30 a.m. And their own witness, Rebecca True, helped prove what we already knew. She said, all I can say is I was in Marco Island when this happened. But the defendant sent her a selfie from their home in Fort Lauderdale at 5 p.m. on Thursday. And then the next morning, he sent her the video of himself playing with her son at their house in Fort Lauderdale. So we know those parameters right there. What was he doing in between there? So Rebecca True gave us those parameters. Well, now we look at his phone records, because guess what? When the detectives go down there and say, hey, James True, we need to talk to you. Your DNA was found at a crime scene. Can we look at your phone? Sure. Sergeant Pinder didn't need to get a search warrant for James True's phone because he said, here it is, and handed it right over to him. And then there at his house, if you recall, Sergeant Pinder downloaded the contents. And what do we know from James True's phone? He took a selfie in Fort Lauderdale. He liked to take selfies, clearly, on Thursday, March 23rd at 7:47. His phone shows at 7:47 he was in Fort Lauderdale taking a selfie. And then he took another photo of a tag, some sort of tag on a vehicle, at 11:05 in Fort Lauderdale. This is on his phone, 11:05. And his phone records show he received an instant message from Wells Fargo to verify a credit card charge at Blondie's Sports Bar at 12:54 a.m. At 12:54 a.m., he was at Blondie's Sports Bar doing whatever he did there. Blondie's is in Fort Lauderdale. Sergeant Pinder told you that. He personally knows that he's from Fort Lauderdale. That's a 4 to 5 hour drive to Marion County. Because we know he was back by 9:30 the next morning because he sent Rebecca the video. There's no way James True made it to Marion County, murdered Tim, and then made it back to Fort Lauderdale by 9:30 a.m. to send that video to Rebecca. He may be a despicable human being, but he did not murder Tim Smith. That's impossible with the evidence that we have shown to you. And all of this evidence is there for you to review. Lloyd Kelly. His DNA was on a lubricant bottle cap that was in the apartment. He testified by Zoom. He's in Virginia. He was meeting random people on Grindr for sexual activities with his wife. He doesn't even remember having sex with Tim or the defendant. He doesn't recognize the apartment. He said it's very common for people that he and his wife would meet at hotels to bring their own lubricant. And the defense attorney made a big deal about asking everybody, did you ever obtain a sample of Lloyd Kelly's DNA? Nobody went and swabbed his cheeks, but nobody's disputing that that was his DNA. They got the hit back from CODIS, which is a DNA database that said it was Lloyd Kelly. And he's in there because he's a convicted felon and he's on probation. Got that. Nobody's disputing it. We don't need to go get another swab from him to prove it. It's his. Nobody's disputing. We're not disputing that. But unlike this guy, there's no reason in the world Lloyd Kelly had to kill Tim. There's been no evidence of a reason, no evidence that he even slept with Tim. We don't know. No reason. I mean, he was married, but his wife was participating in the sexual activity that he was doing with other people. There was not a lick of evidence or a reason Lloyd Kelly would want Tim dead. But there's 1,000 reasons he wants Tim dead. So let's move on to 2, which is the last thing we need to prove. Is there any evidence that Tim left that house on his own to go to the apartment to have sex with some unknown person? None. All the testimony's been Tim was in his PJs at 9:30 ready for bed. The defendant told every officer he saw that. Jordan says that. We know he had a big interview with Nina Corsi the next morning, a very important interview, one of the final interviews to get his job. There is no evidence on his cell phone going back several days, up to Thursday, that he would have any planned meeting with a person. There was nothing, meet me at the apartment at this time, let's hook up at this time. There was nothing on his phone talking about meeting anybody at the apartment. There's no user activity on Tim's phone after 9:45 p.m. Nothing. Because at 9:30, he's ready to go to bed, and there's nothing after 9:45. The diphenhydramine level, we can't get around that. I mean, he most likely was not even awake, let alone conscious. There's no way that guy was driving to the apartment to have sex with somebody. He couldn't drive, let alone have sex with somebody with that level of diphenhydramine in his system. There is no way. And also, he didn't take his erectile dysfunction medication, which is tadalafil. And if you recall, the tadalafil was found in the apartment. His name's on it, and he's supposed to take it when he needs it. I asked Dr. Corey about that. When you got the blood results back, did the blood results check for tadalafil? Yes, they did. They screened for that medication. Was that in his system? No, it was not. Certainly he would have taken that if he was going to meet somebody at the apartment. The diphenhydramine surely was in there, but the tadalafil was not. So we know that there is not a shred of evidence that he was going to leave that house and go to the apartment. None. That's all speculation and conjecture on the part of the defense. The marriage was over. I think we've proven that beyond a reasonable doubt. It started deteriorating in 2019 when they joined AA. Jordan said they stopped drinking, they started arguing. And going back a year before the murder in May of 2022, Diane DeLucy, she hired the defendant to do some work at her house, and he was there a couple times. And she said he was very angry with Tim. And he yelled and screamed while he was there, yelling, "Tim owes me," and Tim is a lazy SOB. And she demonstrated for you how he said those things about Tim. This is just about a year before Tim was murdered. That's when things started their downhill spiral. And in the months leading up to the murder, Jordan would go to work early. She was working at Laredo's Italian restaurant. She would go early just to get away from all the fighting that was happening in her house. But by March of 2023, we know things were really, really bad. And you heard from Jessica Hendricks and Michael Horton. And they were friends with both Tim and the defendant. These aren't any people that were like, oh, we were best friends with Tim and we didn't like the defendant. They were friends with both of them. And they said about a month before Tim was killed, they hired the defendant to put in a sink, like a salon sink at their house, and it took a long time, about 6 or 7 hours. And all he did for almost the majority of that time is complain about Tim and their relationship. They described him as being frustrated, angry, and defensive. And remember, they weren't asking him questions. I said, were you asking about the relationship? They were not asking questions. That's a long time. Think about how long that was, how mad he must have been to spend so many hours venting about Tim. He told Jessica there were problems in the relationship and they were breaking up. He told Jessica that Tim can't take anything from him. He's a hardworking man and he supported the family, which we know is not true. And you have all the financial records which are in evidence. And the defendant told Jessica if he had to do it all over again, he wouldn't marry a man. He was done. He was mad. He told Michael about Tim's new job. He was not happy about that either. He told Michael Horton they were fighting a lot and they were probably going to split up. And the demeanor that everybody describes is angry and mad. And if you recall, Michael Horton tried to console the defendant because they were friends. So I mean, he's got no reason to make any of this up. I said, what did you say to the defendant when he was complaining? I tried to console him because we were friends. You've got no reason to come in here and make any of these things up. Now, we did put some hospital records and evidence, which I'm going to show you, but Jessica and Michael were about a month before Tim was killed. Now we move on to Sunday, March 19th of 2022. This is 4 days before the murder. Tim was in the hospital. The defendant went to brunch with their group of friends from AA. And he sat next to Daryl Levine. And he started telling Daryl that Tim was getting another job, and he was very unhappy about it. And he told Daryl, if Tim thinks he's going to get another job and leave me with nothing, he's got another thing coming. Did that happen? Did he say that? Yes. And we also know because Kevin Branch heard it. He was at the brunch and you heard him say it. And if you recall, he said, the defendant wasn't even talking to me. But because of the intensity with which he was saying these things, I turned to look. So imagine, you're at a big brunch, the intensity with which the defendant was complaining about Tim was so strong that Kevin turned and looked. And he heard him say, if Tim thinks he's leaving me and taking another job somewhere else, he's got another thing coming. And then the defendant also told Daryl, which really bothered Daryl, Jordan and I loved Tim. We really did. In the past tense. All of these witnesses and all this testimony confirms, there's no question this marriage was over. And think about this new job. You heard a lot about that and you probably wonder why. Well, think about that he was willing to leave a job he had been at for 7 or 8 years. He loved that job, everybody loved him there. This was not a big pay raise. He wasn't getting a big pay raise. Nina Corsi said, look, he was making more than we were willing to pay, but I was going to get the management, the owners, to come up to what his salary was because she wanted him so bad. So he wasn't getting a pay raise, and he was going to have to relocate. He was going to have to leave all of his close friends, and you've heard about the close group of friends that he had. And think about this, he was also going to have to leave Jordan. I mean, Jordan was like a daughter to him. He and the defendant had been together since she was 8 years old. How bad were things with the defendant that Tim was going to give up everything he had and loved in Ocala to get away from this guy? He was going to give it all up for no more money and to leave everything. And we know he definitely wanted the job because Nina Corsi said, well, she was surprised too that he wanted to leave Brookdale. She was surprised. Tim said he was very excited for a new opportunity and change. That's what he said. The last thing that Tim emailed Nina Corsi, she testified, was, can't wait to talk to you, looking forward to it, at 9:43 on Thursday, March 23rd. That final interview was Friday at 9 a.m. And you know he was going to get the job because Nina said, I told the owners, this guy's great, he's very professional, we need to make him an offer. And she said when she recommended someone to the owners, they always went with what she said. But think about how bad things were that he was going to give up everything he loved to get away from this guy. And how did the divorce affect the defendant? Well, we know because he told everybody how financially destitute he would be without Tim's salary. He told everybody, after Tim died, I need the life insurance money, I'm struggling financially. There's no question that he could not afford to live the way he was without Tim's salary. The day after they found Tim's body, Candace Baker went over to the house. And she said the defendant was already in the office looking for the insurance papers. And he told her, I need my money. The day after they found Tim's body. Why? Because that's why he did it, so he would have the life insurance money. He told Jordan multiple times he needed the insurance money to pay the bills. He told Victor Gardner multiple times he was struggling financially. He told Daryl Levine he was having a hard time getting the insurance money and he needed it. He told everybody that. That was no secret. And he talked about getting the insurance settlement and that he was going to take a big trip in an RV to the mountains once he got his money. Now, Deputy Kyle Shaw is the first well-being deputy. He did that check on Friday, March 24th. And if you recall, the defendant did everything he could to make sure that that deputy had no reason to make forced entry into the apartment. everything he could. Deputy described the situation as nothing urgent, nothing to cause alarm or suspicion. He said the defendant made it seem like it was not that big of a deal. The defendant told Deputy Shaw, "Oh, Tim meets clients here and then he leaves in their car all the time. No worries." Based on what the deputy saw and the defendant's lack of concern, lack of urgency, there was no exigent circumstances and Deputy Shaw could not break into the apartment. And the defendant told Sergeant Pinder that Deputy Shaw told him to go check the hospitals to see maybe Tim's there. Which is interesting, because guess what? The 2 weekends before the defendant murdered Tim was in the hospital. This is March 11th of 2023. This is 2 weekends before. Tim goes to the hospital because he was complaining of waking up in the morning, trying to get out of bed, and then passing out and falling on the floor. He woke up, he was weak, and he was unable to get to the bed. Once he was helped to the bed, he was seeing double vision, and he again passed out. 2 weekends before, Tim's at the hospital. He doesn't stay that day, all the hospital records are in evidence. He checks himself out, they do a bunch of tests, they're like, "We don't know what's wrong," and he leaves. But guess what? He goes back the following weekend. And this is the Saturday before he's murdered, March 18th. He goes back to the hospital again. Same thing. He says, complains of weakness, difficulty getting his words out, and it began at 00:30, which would be 12:30 in the morning, when he woke out of a sleep. He attempted to ambulate to walk to the bathroom. When he became weak, he had difficulty getting out of bed and difficulty getting his words out. He had to spend the night in the hospital. This is Saturday. He spent the night at the hospital and got discharged on Sunday. This is the Sunday that the defendant was at La Cuisine having brunch, while his husband was in the hospital for the second weekend in a row. And these are the things. He's passing out. He's dizzy. He can't get his words out. This is the weekend before his body's found. Knowing that, how do you not tell the deputy that when he comes there on Friday, when you call him? You don't tell the deputy, "Oh my God, my husband has been in the hospital the past 2 weekends. He's been passing out, he's weak, he can't talk. We don't know what's wrong with him." You don't tell the deputy that? It's because you don't want the deputy to go in there, and you already know that, you know Tim's dad in there.
Excuse me. Can I'll push for a second.
What is the normal response for someone whose spouse had just gotten out of the hospital? What is a person's normal response? Kick in the door? Is Tim passed out in the apartment? His Jeep's here. He's passed out the past 2 weekends. He hasn't even been able to get to the bed. A person's normal response would be to break in the door. He was a handyman. He put that door on. He could fix the door. His excuse is, "I didn't want to get arrested, so I didn't kick in the door." Okay. He didn't do that. He didn't do any of that because he knew Tim was already dead in there. Even if he didn't want to kick in the door, he would have certainly told the deputy. And the only reason he didn't do any of that is because he knew Tim was already in there dead. Because if he didn't know that, he would have forced entry into the apartment or certainly told the deputy, because then the deputy would have been able to go in there under exigent circumstances. And even further, when he finally gets Jack, the landlord, to meet him at the apartment with the key, he still doesn't go in. If If you recall the body cam, the deputy comes up and he's standing against the car with Jack, the landlord. Jack was asked, why didn't you guys go in if you were both there with the key? And Jack, the landlord, said he didn't want to go in. I don't know why we waited for the deputy. I mean, his whole thing is, I don't have a key, I don't have a key, I can't get in. Well, when you finally get the key, and you're standing there with the landlord, why don't you go in then? And he'd been there the weekend before, on his own without Tim. The landlord is there, there's no reason not to go in. The only reason is because he knows Tim's already dead in there. He's got a key and he's just kicking back with Jack, waiting for the cops to get there. There's no other reason he didn't go in there with the key. And these are, you heard about the text messages that the defendant sent to Tim over Thursday night and Friday and Saturday. And these are just two that I put up here from Saturday. And the first one's at 5:48 in the morning. The defendant is trying to cover his tracks. He's got to make it look like I'm looking for Tim. He says, hey, Tim, still haven't heard from you. Spent all night, still worried. Please give me a call if you get a chance. Love you. Of course, no response. Then at 6:06, hey babe, I have no idea where you're at. What's going on? I'm heading to work in the Villages. Please give me a call. Is this a realistic text that you're gonna send your husband who hasn't contacted you, hasn't called you, hasn't texted you? You've got the police involved. If you didn't kill him and you're really worried about where he is you just gonna be like, hey babe, I don't know where you are? Or are you gonna be like, call me right now, I've called the cops, where are you? This is
I'm
just a
gonna
cover-up.
object to golden rule again,
Sustained.
and I would move for a mistrial at this point.
Then, Jeff, I'm going to ask you to step out just for a few moments with the bailiff. Hi, sir, the jury is out of the courtroom. You had an objection, I sustained the objection. Is there anything further you want the court to consider?
Yes, I would ask the court, I would move the court for a mistrial. The state initially crossed that line into golden rule territory. The court caught it, it admonished the parties, and now it has happened yet again. The only recourse, I don't believe a curative instruction is enough to overcome what has occurred. For a golden rule, the remedy is a mistrial. So I am moving for a mistrial at this point, and would ask the court to grant the motion.
Ms. Byrne?
Judge, after we discussed that at the bench, I said a person the next several times. That was the first time, if I said you, that I said it after a person. I clearly said a person all the times after that.
All right. First of all, I don't find there was a true golden rule violation, which is when an attorney is trying to put the juror in the place of the defendant or the victim in order to gain sympathy, in order to, generate some sort of empathy, anger, anything else along those lines, because that's not appropriate for the jury to consider. I noticed Ms. Byrne saying you. As I told you guys when I called you up, I just said, hey, let's kind of be careful about this, because my opinion, and what I said when you guys came up here, in case the record wasn't clear, is that I believe she's using you in kind of the omniscient, like not you as a juror, just like you as in, the omniscient, the world in general. She was using it to describe how generally a person might feel or do, and then comparing that to what the defendant did. I find that I believe in this situation, and what I find is that there's no intention to put the jurors in the play, or make the jurors feel like they're in the place of the defendant or the victim or anyone else, is simply a manner of speaking, a way of describing events, a way of describing actions, a way of describing thoughts. Like I said, I don't think that it was a golden rule violation. I just ask you to be careful because sometimes people might interpret it as that. Because, for example, if you said, Juror A, how would you feel if someone came behind you and strangled you? That would be a golden rule violation. Here, I think, like I said, it wasn't being used to particularly have a juror be placed in the position of victim or defendant, just kind of used in the omniscient. And then instead of saying, how would a person feel, she said, how would you feel? There's really very little difference in that. And it's really just a manner of speaking. So I'm going to deny the motion for mistrial for those reasons. But again, caution you that, and it may just be the way you communicate. We all communicate differently, you know, but we do have to be careful to instead of saying the word you, saying how would, I mean, you know, a rational person or
Yes,
anything like that. And I understand this is a closing argument. It's when any person is making an argument in front of a tribunal, you got to think about what you're saying, you got to think about the facts, you got to think about the law. You're not always really careful enough to make sure that you speak in this perfectly neutral manner. You kind of just use your regular way you might communicate with somebody. And that's what I think is happening here. Again, I don't find there's an actual intention to make the jurors feel empathy, sympathy, or be in the place of the victim here. That would be problematic, like I said, and I think I described the differences between the two. But it is a court of law, so I ask everyone to be careful about how we phrase things. But I'll deny the motion for mistrial at this time. Do you want me to give a curative instructions or not? Mr. Klein?
No, Your Honor, I don't believe a curative instruction would be appropriate. I believe the only remedy is a mistrial, and I respect the court's ruling in that regard.
Okay, thank you. All right, so with that, we'll bring the jurors back. Thank you. Welcome back, ladies and gentlemen. We're ready to begin. Go ahead, Ms. Burke.
Thank you. As I was saying, these are the two texts that the defendant sent to Tim the morning that his body was found, on March 25th. All of the defendant's actions show he did not care that Tim was dead. What did he do after they found Tim's body? He wasn't upset at all when Deputy Hunt's body came, which you saw. When he said, deputy came out, the defendant asked, is he in there? The deputy said yes. The defendant said, is he okay? The deputy said no, and he just went. He never asked, what happened? Was he murdered? Did he commit suicide? Can I go see his body? Didn't ask any of those things. Just said, whew. And then when Deputy Hunt said, I'm gonna call major crimes, he didn't ask, was he murdered? Why would you call major crimes? What happened to him? Was he shot? Was he stabbed? Doesn't ask any of those questions. And Sergeant Pinder talked to the defendant right after they found the body in his car. And he said the defendant was pleasant and calm. Nobody that talked to the defendant Saturday when Tim's body was found, or any of the days after that, said the defendant was upset. Nobody. They all described him as normal. And the defendant, this is Sunday when Candace Baker talked about this. Sunday after they find the body, the defendant is throwing all of Tim's things away. Everything. Clothes, knickknacks, food, vitamins. Professionally taken photographs that were hanging on the wall. The defendant took them down and had a stack on the table. Everything. It was a fire sale, get rid of it all. Why? Because he didn't care. He killed him, he got rid of him, and we're moving on. And he told Candace. Candace was very upset. And he said it was his house and he could finally have it the way he wanted. Are these the actions and the things of a man who's upset? That his husband, that he's been with for 15 years, is dead? And the next morning, early in the morning after they find Tim's body, he's on Grindr, the dating application where they meet men to have sex with them. The following morning, 2 people saw him on that, not just one. And he took all of Tim's books and journals and a strip of photographs and donated them to Soul Essentials. And that was 5 days after they found Tim's body. And Daryl Levine said the defendant was at a gay campground the weekend after Tim's body was found. He said it could have been the weekend after, 1 to 2 weekends after Tim's body was found. The defendant was happy and having a great time by the pool. That's what he was doing. And then he moved his friend Kevin into the house and was sleeping with him in the bed he shared with Tim. Victor Gardner told you that Kevin had moved into the house, and Jordan told you they were sleeping in the same bed. This is the picture strip that the defendant got rid of when he donated all of Tim's things, and this is Tim's journal. And you can see from these pictures, they appear to be younger. They appear to be very happy in these pictures. And this is Tim's journal, where he's written things about himself. Hugger, comforter, compassionate leader, good listener. The defendant got rid of those things. If he loved Tim and was upset that Tim had been murdered, these are pictures of a happy time with Tim, where Tim wrote words that described himself. If he cared about Tim and hadn't murdered Tim, he would keep this forever. This is a big thing he got rid of 5 days after. Now, besides all of those things, and all of the testimony from everybody that said they were fighting, he hated Tim, he said he wasn't going to let him leave without him, he needed the money, and the insurance records are in evidence, you can look at those, and there's the 401k as well as the $333 of life insurance. There was a retirement policy, and that's in evidence for $48,000, and he was the beneficiary of all of those, and we know how badly he needed the money. But on top of all of those things that I just went over with you, we had the video proof. Now remember that the defendant told everyone he was home all night sleeping. Everybody he talked to, from friends to first arriving deputies to Sergeant Pinder. He told Deputy Hunt in that body cam he takes sleeping pills and was asleep all night Thursday night. He told Sergeant Pinder he took melatonin and he sleeps hard. That's his quote. The videos prove he was not sleeping all night. And I tried to condense these and make these as easy to follow as I could. I know you heard a lot about different times in videos. The first thing that happens is the defendant driving his truck to the apartment after he murders Tim. And I want to go over this map that I know you saw a lot of quickly. Right here is where Tim and the defendant lived. This is Pedro Vasquez's residence, where we have a lot of video from. Down here, this is not a road. There's one house that's down here with one person that lives here. So if the defendant is going to leave his house, he either comes out the front way and has to come up this road to get to 52nd, or he can come out the back of his house this way and come out here. So those are the only two ways in and out, are this way or this way, right here. And Pedro Vasquez had cameras at both of those places. So when the defendant was supposedly sleeping hard, we have his truck leaving the residence. And the first time we have it leaving, it's coming out this way. So it comes out this way, it goes here, passes the Vasquez cameras, and goes up. This is a picture of the defendant's truck, and we talked a lot about that it was distinctive because it looks like the tailgate's down in this picture, but it's not. The tailgate is up, and the whole truck is white, and this tailgate is black. Now this is Friday, early morning, 1:59 a.m., when the defendant was supposedly sleeping. This is the same time that Tim's phone leaves the house and moves towards the apartment. Tim's phone is moving, Tim's body is in there, and the black bag is in there, and this is the defendant's truck, and this is from the video. It's just a stop. The video stopped right here. This is him passing the Vasquez house, going up the road right there. And he's the only one that had a white truck like that, and leaving at 1:59, the same time. You can see the picture, clear as day. And this is the other one. If you remember, the Vasquez had two camera angles that were going on that road. This is the other camera angle. Here we go, we're leaving. 1:59 a.m., same time Tim's phone is moving. Here's his truck. And we passed by some more things. I know you've probably heard more than you ever want to hear about these places. Green for Life. This truck passing by here. And this time is approximately 2 a.m. And if you recall, the time was off on the Green for Life camera. And we made sure that we had the person who actually got the video and worked at the store talk to you about whether the time was off. Plus the deputy that collected the video also told you whether the time was off. And they both testified that this would be approximately 2 in the morning. So he leaves his house around 1:59. He's passing Green for Life at 2 a.m. Now this right here, if you can see, is the true green right here. Triple Crowns. He's passing at 2:02 on Friday. Triple Crown. And this is his truck, going by right underneath the red. And now the Marathon gas station, 2:02. And they said that they're right by each other, so it would be about the same time he'd be passing the Marathon and the Triple Crown. Here you go. That's his truck. So you have him clearly leaving, passing by Pedro Vasquez's, passing by those 3 businesses, exactly the time he would be passing them to go to the apartment. So he gets to the apartment, and then he's got to come back home, because now we got to get Tim's Jeep. So now he drives the truck back to the apartment. He's put Tim's body and Tim's phone in the black bag in the apartment, and he's there about 20 minutes. And now he's coming back. And this is the Marathon. There's the truck right here, 2:23. He's there about 20 minutes. Here's his truck going the other way, heading back towards the residence, right here. Triple Crown, 2:25. Right here is his truck, heading back to the residence. And there's no video of him coming back through the Green for Life, because if you recall, the deputy said that for some reason skipped ahead a few minutes, so the time that he would be passing by there wasn't on the video. That's why there's no Green for Life. So he gets home. And this is him passing by Pedro Vasquez, coming back home. Right here. This is 2:27. As you recall, he lives right down here. And he's got a fence. And you're going to see him turn right into his house. comes. Coming right by. And we know that that's his house, the direction he's going. Because that's the only thing back there. Now what is he going to do? Now he's got to get Tim's Jeep to the apartment. And this now is 2:40 in the morning. So he's gone home, he's been there for a couple minutes, now he's doing Tim's Jeep. Got to get that there. And again, this is coming right from his house. There's nothing else down here. That's coming from his house. Tim's Jeep moving out now. $240. Now, we have the Jeep's going to be taking the exact same path that the truck took. 241, passing green for life. Tim's Jeep. Going by the Triple Crown, 203. I'm sorry, 243. The correct time because the video camera was off. And this right here is the Jeep going by at 243. There's the Jeep right here. You can clearly see it. This is the Marathon. 243, because those are right by each other, so the time's the same. This is clearly Tim's Jeep. 243, going to the apartment. And now you heard that Tim's phone was found in the toolbox in the apartment. That toolbox is right by a window that faces the parking lot. So when the Jeep pulls up to the apartment, it connects with Tim's phone because he has the Bluetooth. So Tim's phone is there right by the window in that toolbox, and when the Jeep pulls up, they connect. And here's the report that's in evidence. And this is at 2:44. We know the Jeep connects with Tim's phone. That's when the Jeep is pulling up. And again, this is in evidence. This right here is from 6:45 because that's when he got home Thursday on the 23rd. He came home and disconnected from the Jeep. Now here you are right here, 3:24, 2:44, connected and then disconnected. 2:44, the Jeep pulls up and connects with Tim's phone, which is in the apartment. There's more evidence, and all of these things just confirm all the video. But we have the other video, and I call it the cat video, because the cat's the one that set it off, if you recall. And what do we know about that? This is very small, I wrote it bigger here, it's on the bottom, it says 2:32 right here is the time. This is from Stuart Mitchell. He's funny, he said, I was nosy, so I looked out to see what was happening. So this is his apartment, and he has his camera that faces right here. If you look at the bottom here, you can see the cat that sets it off when I start playing it. A cat walks by and sets it off. And as you can see, at 2:32, the Jeep is not there. This is where we're looking. This is where the Jeep eventually ends up. The Jeep is not there. There's the cat right there on the bottom. No Jeep, 2:32. Now, we're at 3:26, and you know that because you can see in the bottom, it's very small, 3:26. The cat sets it off again, you'll see the cat. Here's the Jeep. The Jeep is there, the Jeep was not there before. Because we know the Jeep got there at 2:44 because that's when it connected to Tim's phone. And clearly, if the Jeep does not set off the motion activation on this camera, then if the defendant parked on the other side of the Jeep to go into the apartment, it's not going to set that off either. That's common sense. So the Jeep didn't set it off, A truck parked on the other side is not going to set it off at all. You see the cat right there on the bottom, set it off, and now Tim's Jeep is there. So we know it wasn't there before, and it's there now, and all of this evidence just corroborates everything that we have. Because we know it got there on 244, it was there. Now the defendant has to walk back home, because he's left the Jeep. And Detective Pinder had to look through a lot of video, but he found him walking. And I put a red circle around so you can follow. I know it's hard to follow. This is the path that he's walking, starts here. Walking, walking, walking. This is at 251. This is from the Marathon gas station. Now, you'll see when the red circle starts and it follows. But if you watch, you can see when he walks by somewhere where there's a light. Like right here, it will go dark when he walks by. And then when he gets right here, you can see him walking through. And especially right here, you can see the body walking. Remember, look right here because you'll be able to see when he walks by there. See him walking right by there, and you'll see it again right here. He's moving. He's got to get home. Again, crosses right by. You can see when the light right there goes off when he walks by. According to Google Maps, which again are in evidence, it would take 35 minutes for the defendant to get from that spot at the Marathon gas station back to his house walking. That would put him at his house at 3:26 a.m. He is accessing that Ring doorbell camera at 3:26 a.m. Can't get around that, the phone records are in evidence. When he was sleeping hard after he took his melatonin, he somehow is accessing the Ring doorbell at 3:26, the time he would get home after that walk. And then after that, he's on Facebook, Grindr, and Gmail until he leaves to go to the gym. Jordan Swilley. In a case of a death by 1,000 cuts, this is the final cut, right here, Jordan Swilley. She's obviously in a terrible position. She loves her dad. She loves Tim, who's like a second father to her. She said she got woken up because she heard a noise. She doesn't know what kind of noise, but the noise woke her up. Her Ring doorbell app was going off after the noise multiple times, she said. She didn't check it, but it went off multiple times. And the next morning, the defendant asked her if she heard anything. She said yes, and the defendant said, "You were sleeping, that's all you need to remember." I asked her, "Did the defendant ask you to lie for him?" She said yes. He told her, "If anyone asks, I was home all night." But we know he wasn't home all night. She was upset, she was confused. She went to her best friend Layla's house to talk to her about what she heard that night before and what her dad had told her. And then she even had to go to see her friend Allison just to get a hug. She was so upset. Tim was gone, she didn't know where he was, and her dad was telling her to lie for him. Probably one of the most important pieces of evidence that she said is that Friday night after they went to the apartment, her dad made her stop at a gas station so he could throw away a pill bottle because he didn't want to throw them away home. That was the alternative. He didn't want to get home. This case has clearly been proven to you beyond every reasonable doubt. We would ask that you find the defendant, Herbert Swilley, guilty of first-degree murder. Thank you.
Thank you very much. Mr. Clowney, you ready to begin?
Ready, Judge.
it's been a long week. My colleague, my client, and I are grateful for each of your time and attention during the course of this lengthy trial. And the best news is that it's coming to an end, right? So thank you for your time. I know it's a sacrifice. We watched some video evidence a few moments ago. We know who's driving those vehicles. Sure, you see vehicles that appear to be a white truck and the white Jeep that belonged to the victim, and appears to be the white work truck that belonged to Herbert, my client. But we don't know who was driving those vehicles. We see something walking by the Marathon gas station. We don't know who that person is. State wants everything to fit neatly into their timeline because that's their theory of this case. But that's just what it is. It's a theory. They have video evidence to support that theory. But what evidence do they have that was presented that supports the theory that Tim Smith was murdered at the marital home and his body was then moved in Herbert's white work truck to the apartment and staged? Did Sergeant Pender, who was a detective for the majority of his time in this case before he got promoted to his current position, did Detective Pender ever take the time to process that white truck for blood, prints, DNA? No, he didn't. Did Detective Pender ever take the time to have his crime scene forensic technicians process that white truck? No, he didn't. Did he take the time to have his crime scene technicians process the marital home for these items? No, he didn't. I will say, though, that the Marion County Sheriff's Office did a thorough processing of that apartment. They were there from the time that the body was discovered in the late morning until the late evening that night, almost midnight that night. So 12 hours, give or take. They were there collecting evidence, taking pictures, processing the crime scene thoroughly. And what did that processing reveal over the course of time? It revealed latent prints of value. It revealed DNA evidence of value. And these latent prints of value and DNA of value were whose names were not Herbert, but instead James True and Lloyd Kelly. And the state wants you to believe that James True it's impossible for him to have committed this crime because it doesn't neatly fit into their timeline. Their theory of the case. You heard from the medical examiner very experienced lady who said that the time of death is determined from the last time that person is known to be alive until the time that their body is discovered and they're deceased. That date range in this case is from Thursday, March 23rd, 2023. 9:30 p.m. was the last time Tim Smith was seen alive by Jordan. Up until Saturday morning, March 25th, 2023. So we have a span of 2 days. And the last time that Rebecca True knew of James True's whereabouts was 9:30 a.m. Friday morning, March 24th. She doesn't know where he was or what he was doing after that. And remember when Sergeant Pender testified the first time around, he said that he had used the license plate reader system to do a search on what he believed to be James True's vehicle, the Cadillac Escalade. And he couldn't find anything on those license plate reader results which would indicate that James True, that vehicle anyway, was in Ocala during the date ranges of Tim Smith's time of death in this case. But according to Rebecca True, that Cadillac Escalade had a breathalyzer in it. And James True is an alcoholic. So when her Volvo SUV was available to him, it would not be uncommon for him to use that vehicle instead. But Sergeant Pender said he didn't even know James True was married. He couldn't remember what other vehicles were there at their home in Parkland when he went there to visit. He was searching for the wrong car. And what about Lloyd Kelly? We heard from Lloyd Kelly. He testified He testified he's a multi-convicted felon, that he's currently on felony probation, that he and his wife would meet people on Grindr and have sexual encounters with them. He didn't recall Tim Smith, but the evidence is what the evidence is. And his DNA, Lloyd Kelly's DNA, was on that gun oil lubrication bottle that was discovered in the same room where Tim Smith's body was found in that apartment. Initially, Herbert Swilley was cooperative with the investigation of Tim Smith's death. He had contacted Marion County Sheriff's Office to do wellness checks on Tim Smith. Ultimately, Herbert obtained a key from Jack, the landlord, which was provided to Deputy Hunt, who made entry into the apartment and discovered Tim Smith's body. And we saw the body camera from Deputy Hunt, so we know exactly what he saw. And the state wants you to believe that Herbert had no reaction on that body camera. But if you watch the body camera, if you need to see it again, it'll be available for you all to review as many times as you want. Everyone grieves in their own way. And at this point in time, Tim had been missing for a few days. It was unlike Tim to not show up for work. That was just not Tim. Herbert very well could have known there was a problem given that. So it was not entirely surprising to him that no one was answering the door, that Tim was not responding to text messages, and that Tim was not okay. And speaking of that cooperation that Herbert initially provided to law enforcement, he did the walkthrough of the apartment with Detective Pender after Tim Smith's body had been removed on the day he was discovered. And he pointed out some things that were rather important, because Herbert used that apartment too. He had just been there the weekend before. And Herbert pointed out that the gun oil lubricant bottle was not in the place where it was supposed to be. It was discovered in the room that had a bed in it where Tim Smith's body was. But it was supposed to be in the neighboring room that had the massage table, the toolbox, and the adult wing. But it wasn't there, and Herbert pointed that out. And lo and behold, that item had two different known offenders, either print or DNA on it. James True and Lloyd Kelly. He also pointed out that there should be no bleach. Tim Smith doesn't use bleach, gives him a headache, They don't keep bleach in the apartment. And he pointed out that there were some towels that were missing. Herbert allowed the sheriff's office access to Tim's white Jeep, which was still parked outside in the parking lot. They took pictures of it, and then they released it to Herbert. Herbert allowed Detective Pender to look at his phone, to look at the ring application. But Herbert was damned if he did and damned if he didn't. And I say that because look at what his cooperation did. Detective Pender claims he looks at Herbert's phone, he goes onto the ring application, and he finds these still images of what he later determines, even though he's not a ring expert, determines were deleted videos. And that's an important piece of evidence if it truly ever existed, because it's the only thing that definitively would prove that Herbert was not inside the marital home asleep on the morning that the state claims, according to their timeline, this murder and body move took place. Yes, you have the vehicles on video. Yes, you have a stick figure walking by a Marathon gas station, but you cannot identify who's driving those vehicles or who that stick figure is. Herbert is damned if he doesn't. He gets concerned. He gets a lawyer. He takes the Jeep, instead of taking it to an appointment with Detective Pender, he takes it to his lawyer's office, Gail Grossman at the time. And Gail ultimately, voluntarily provides the keys to law enforcement on Herbert's behalf later the same day that there was an appointment that Herbert missed. Perhaps at the advice of his own counsel at the time. And what happens from there? Detective Pender starts ramping things up against Herbert. He obtains a warrant for Herbert's phone. He obtains a warrant for the ring cameras that are on the property. He is concentrating more and more on Herbert Swilley and Herbert Swilley alone as the primary suspect in this murder investigation. Totally oblivious to the fact that there was another person living in that home who was an adult who he needed to be investigating. And that person is Jordan Swilley. Who else would have had access to those vehicles other than my client? Was there any evidence presented that Jordan didn't have access to those vehicles? Rely on your own recollection, but I don't recall that. And is it not possible that that vehicle movement and activity was unrelated to the death of Tim Smith? Detective Pender did not get the cell phone data for Jordan Swilley until 8 months after he started his investigation of this case. By then, Jordan had gotten a new cell phone, and he was not able to retrieve the location data from her phone for the period of time in which Tim Smith was killed. And then there was an effort made to say, well, but I didn't do that because Jordan had a lawyer. Until the defense pointed out that, well, Sergeant Pender, you didn't learn Jordan had a lawyer until May the 30th, 2023, which was more than 2 months after Detective Pender's initial involvement. And a little bit more on this timeline and theory of the case. Is there any direct evidence showing that my client, Herbert, was at the apartment that the couple used for sex with others on either the evening of March 23rd, 2023, or the early morning hours of March 24, 2023? And the answer to that question is no. No one saw Herbert there during that date and time frame. Herbert was not captured on any video surveillance at or outside the apartment during that date and time range. There's no evidence placing him at that apartment during the period of time that the state claims, according to their theory of the case, that the body of Tim Smith was moved and placed there. How does one know that Tim Smith was even murdered at the marital home? How does one know that Tim Smith was given these drugs by the defendant? Sure, they have the statements that the defendant made to people that he thought were his friends, to people that he did work for, that he was unhappy, that he was having marital problems. That is what we call circumstantial evidence and or evidence of motive. But where is the direct evidence that he drugged his husband? Where is the direct evidence that he killed his husband at the marital home? It's not there. But there was direct evidence presented that James True is a violent guy. There was direct evidence presented that James True has used physical violence against another. There was evidence presented that James True threatened to kill another. Another thing that is rather interesting is that when they did that very detailed processing of the apartment, the victim, Tim Smith, had two phones. One was a red iPhone, that was the work phone, and the other was a Samsung Galaxy, which was his personal phone. There was a extraction, a Cellbrite extraction done on Tim Smith's personal phone, but there was no extraction done on the red iPhone, the work phone. And Jesse Newbanks, one of the state's witnesses in this case, he testified via Zoom on a previous occasion. There was a motion to perpetuate his testimony because he wasn't going to be available during this trial period. He's in training because he works for Homeland Security now. But they couldn't get into the iPhone to download the data because they couldn't unlock the iPhone. So we don't know what is or is not contained on that red iPhone. And we don't know whether or not Tim Smith was communicating with other people on that red iPhone. Because after all, Tim was going to be getting a new job very soon. Perhaps any concerns he might have had about using his work phone for personal reasons had gone down a little bit. Now I want to go back to Jordan. Jordan presents as a person who is stuck in an uncomfortable position, who is along for this unfortunate ride because of her ties to Tim Smith and to her father. But if you look at the evidence, what do you see? You see that Jordan, after her dad was charged with this crime, obtains a durable power of attorney for her father, a copy of which is in evidence, and she's empowered by that durable power of attorney to act as her dad's agent, to handle his monetary affairs, to buy and sell assets, motor vehicles, motorcycles, items that the defendant had. And because the defendant was charged with this crime, he was relying on his daughter to help him manage his affairs. And what does Jordan do, even though she has this fiduciary obligation to her father to act in his best interest? she sells off all the stuff and keeps most of the money for herself. She even sells the land that the marital home was located on without telling her father anything about it, without his permission or consent. She misrepresents to other people that this was a gift and that she would not receive any proceeds from the sale. But she testified that she did. She received cash from a realtor and she put it in her bank account. She claims she gave some monies to her father. Another interesting thing about Jordan is that Jordan is the second beneficiary of Tim Smith's life insurance policies with Hartford. Meaning, if the primary beneficiary, which is Herbert, is ruled out because of the Slayer statute, because it says a homicide, and because Herbert is accused of committing that homicide, then who's next in line? Jordan. So in addition to the monies she's acquired as her dad's power of attorney, she stands to gain even more if her father is convicted of murder. $333,000. Ladies and gentlemen, that is a motive to lie. That is an interest in the outcome of this proceeding. And some of Jordan's testimony against my client is rather damning. Particularly what she claims Herbert told her the morning of Friday, March 24th, 2023, when the two were talking about whether or not Jordan had heard any noises the night before, and what she claims her dad told her to say to lie for him. And the fact that she later would claim that she was with her dad when he dumped some prescription pill bottles at a convenience store trash can. Jordan has a motive to lie for her own financial gain. The state has introduced a wealth of evidence in this case. More than 70 exhibits. But it's not the quantity of the evidence that is presented. It's the quality. The video evidence, most of it, admittedly, is good quality. But it still doesn't tell us who's driving those vehicles. it still doesn't make the link to what, if anything, was in that white truck. Or what, if anything, was in that white Jeep. And we still don't know who it is walking by that Marathon gas station. And the quality of Jordan's testimony, where she states that my client made these statements to her, which would be indicative of involvement in Tim Smith's death, are not reliable. So, with these compilation of things, with these alternate suspects, with these persons who have their own motivations to bend the truth, what does all that come together to be? It comes together to be reasonable doubt. And Tim Smith was well loved, and his death was very tragic and unfortunate. And he was well supported then, he's well supported now. But this case is not to be decided upon sympathy for his death. It's to be decided upon the facts as determined by you, the jury, individually and collectively, and then applying those facts to the law from the jury instructions. And if you do that, and you still have a reasonable doubt, let's say you look at everything and you say, you know, if I could just look at the still photographs that Detective Pender claims that only he could see. If I still need to see that evidence, that's just one example of a reasonable doubt. Ladies and gentlemen, thank you again for your time and attention throughout this busy week. I ask that you return the only true and just verdict in this cause, and that is a verdict of not guilty. Thank you.
1 second, please. Does anyone need a break before we have Ms. Burns' final argument? Okay, Ms. Burns, you may proceed. Do you need the overhead projectors?
Yes, please.
Let me know when you're ready for them to actually go on.
Thank you. I'm not going to stand up here and rehash everything that I've already told you. I just want to address a few things that Mr. Klein talked about. What I gather from his closing argument is that this is the defense. James True did it. But if James True didn't do it, then it was Lloyd Kelly that did it. And if it wasn't Lloyd Kelly that did it, then it was Jordan Swilley. All of those things can't be true. And with Jordan Swilley, I'm not sure if the defense is she did the murder for some reason, or she's lying to get the money. Let's first talk about lying to get the money. If she was lying here so she could get the life insurance money, so her dad would get convicted, certainly she could make up a better story than what she said. How about just saying, hey, the Ring doorbell camera went off, I looked at it, and I saw my dad dragging Tim's body through the living room. That would do it, wouldn't it? I heard yelling I heard screaming. I looked out the door. I saw my dad strangling Tim. I mean, this is, you don't leave your common sense out the door. Use your common sense. If Jordan wanted to frame her dad so she could get the money, certainly she could say something better than, he told me to say I was home all night and that I didn't hear any noises. Now, he kept saying, who's driving? Who's driving the white truck? So I guess if Jordan's driving, then she's the murderer. Is where I guess we're going with that. So that means Jordan drugged Tim somehow. While Tim and her dad were sleeping in the bed, she somehow got Tim out of the bed or started beating him up, strangled him, moved his body, got it in the truck, and then drove it to the apartment and did all those things. Did that happen? Is that a reasonable doubt? I mean, none of that happened. She was 19 years old. She was devastated. And she lost a man she loved and considered a second father and her dad at the same time. And she couldn't support herself. She told you, I sold that stuff. I had the power of attorney. And she used the money to get an apartment. She currently lives in an apartment with her boyfriend and is a server at a restaurant in the Villages. That's where Jordan's at right now. And if she wanted to lie to convict her dad, she certainly could have had something that would put the nail in the coffin, but she didn't do that. And she didn't murder Tim. She had no reason to murder Tim. She loved Tim. She'd known Tim since she was 8 years old. There's been a lot made about why the white truck wasn't processed. Okay, say it was processed. Tim's DNA's in there, the defendant's DNA's in there, Tim and the defendant's blood's in there. Okay, it was their truck. That's not going to tell us anything. Don't be held up on what's in the white truck. We would expect everybody's DNA to be in there. Think about this. Where's that rug? Where's the missing rug? What was on that? We don't know because it's gone. We know that the defendant was certainly at the landfill right when it opened the next morning at 7. What was he doing there? And where's the rug? And why did he not tell anybody about that until a couple days later? He eventually told Sergeant Pender, but they were already talking to everybody, getting video footage, canvassing the neighborhood, because he did not tell anybody he went to the landfill when they first talked to him. Why didn't he tell anybody that, and where is the missing rug? And Tim's work phone, we talked about Tim's work phone. They couldn't get into it, they tried. The defendant himself said, we don't use that phone. That they asked him, what's the number for Tim's work phone? And he said, I don't know. I don't talk to him on that phone. That's his work phone. So now the defense wants you to believe he's going to get a new job somewhere else, so I'm just going to start trying to pick up men on my work phone now. I'm just going to switch from my personal phone to my work phone because it doesn't matter. I mean, that makes no sense at all. And if Lloyd Kelly or James True did it, we have to remember they had to bring bleach with them too. Because there's no bleach in that house. The defendant brought the bleach. So those two masterminds got some bleach and then came up here somehow and murdered Tim. Now the last thing I want to talk about that is very important, it's been made a big deal about.
You ready for the thing?
Yeah. Yes, please. Is the still shots that Sergeant Pender saw on the defendant's phone. You just heard a lot about that. I want to just talk a few things about that. Remember that when the defendant handed his phone over to Sergeant Pender, and they were both looking at the phone, the defendant had already accessed the Ring doorbell camera at 3:46 Friday morning. So he thought he had gotten rid of all of the video. He didn't realize that the still shots had been left on there. So he made that mistake. And remember too that by the time they got the search warrant for his phone and they looked for those, they had been deleted. So after Sergeant Pender looked at the phone and saw those, the defendant got his phone back And then when they looked at it, he wised up, he deleted them, they were gone. Now what's important about this is the timing. And the defense says we're trying to make everything fit. Well, everything fits perfectly in the timing. Sergeant Pinder said, when he looks at the still shots, at 2:25 a.m., the defendant's truck was not there. 2:25 a.m. But then he said the next one was 2:28 a.m. And the truck was there, the defendant's truck was at their residence with a male figure. Sergeant Pinder wrote that in his report right when the investigation was happening. He wrote those times in his report. I saw at 2:25, no truck at the defendant's house. Then at 2:28, I saw a truck with a male figure. Later on, well after he wrote that in his report, we get the video from Pedro Vasquez. And guess what? At 2:27 is when the defendant's truck is passing by Pedro Vasquez's house, going back home. Which would mean the defendant's truck wasn't there at 2:25, like Detective Sergeant Pinder wrote in his report, but it would have been there at 2:28. I mean, the minutes of that, 2:25, 2:28 is what Sergeant Pinder writes in his report. We get the video, and at 2:27, that happens to be passing by Pedro Vasquez's house. There is no chance, it is not possible, and Sergeant Pinder's very smart, that he somehow figured that out and knew that that video was going to show that at 2:27. He wrote those times down in his report before we ever had this video. And it fits perfectly with what the deleted still shots from his Ring camera. $2:27, right here. Here comes the defendant. This is the defendant's truck coming back to his own house. He was not there at 2:25 when Detective Pinder said, I saw that still shot and the truck wasn't there. And there we go, pulling right into his house at 2:28. Exactly what Sergeant Pinder said he saw on the defendant's phone. It couldn't fit any more perfect than what you have right there. And that is why, ladies and gentlemen, the defendant is guilty of first-degree murder. Thank you.
Thank you. Ladies and gentlemen, if you can please listen carefully to your final instructions, okay? Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8. Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? 9. Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1. Whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and has seen in the form of exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for this highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. Your verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. In this case, there's only one. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. It reads as follows. Verdict. We, the jury, find as follows as to count one of the charge. In parentheses, check only one. A. The defendant is guilty of first-degree murder, as charged in the indictment. Or B. The defendant is guilty of second-degree murder, a lesser included offense. Or C. the defendant is guilty of manslaughter, a lesser included offense. Or D, the defendant is not guilty. So say we all, dated, and this is the 19th day of September 2025, and it needs to be signed in pen by the foreperson. We will have a pen back there for you. Please do not sign the verdict in pencil, okay? In just a few moments, you'll be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you are agreed on a verdict, and bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats or they will be guarded by the court deputy while you deliberate. This now includes any sort of Apple or Google watch that can send or receive messages, okay? If you have an old school watch like me, you can keep it. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received as evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. A, the exhibits will be sent into the jury room with you when you begin to deliberate. And B, if you wish to see an exhibit not sent to the jury room, and those are going to be videos which need to be played on the boards, please request that in writing. Everything else you will have, okay? In closing, let me remind you that it's important that you follow the law spelled out in these instructions in deciding your verdict. There is no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we live by the Constitution and the law. No juror has the right to violate rules we all share. What I'm going to do is take the verdict forms I just read and put this sort of paper clip on them. And I have clipped to the back of these instructions the verdict form so it's easy to find. This packet will be used by the foreperson. It's the only packet that has a verdict in it, okay? I also have 11 copies of those instructions, and those will go to the 11 other jurors. I said 11 because only 12 of you are on the jury to deliberate. 2 of you have been serving as alternates, and the alternates will not go back to deliberate at this time. You'll be allowed to go home, okay? But I would ask that the alternates do not look up anything about this case until this evening, because if for some reason something happens to a juror, and hopefully nothing will happen, if that does happen, an alternate will be brought back in and the deliberations will have to start over, okay? So the 2 alternates are Douglas Parker, and if you can raise your hand when I read your name, Douglas Parker and Mark Cole. So for Mr. Parker and Mr. Cole, if you can remain here. First of all, let me say this. Have you left anything in the jury room? So don't remain here. Go get it out of the jury room real quick. And give your badges to the bailiff. The rest of you are not alternates. I never quite know when lunch is going to arrive, but I have not been notified that it's here yet, so we'll bring your lunch to you. So, be expecting a knock on the door at some point, okay? And Mr. Cole and Mr. Parker, if you want to wait for lunches, you're free to do so. We'll be happy to give them to you. You can either eat them here or take them with you. If you'd like to leave, you're free to do that as well, okay? If you can both have a seat, and the other jurors at this point will go back into the jury room. This time you will take your notebooks with you. If you just have a seat real quick. Okay. First of all, I do want to thank you for taking your time to consider the case thus far. I also want to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in a jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your work as a juror. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. Upon a request to discuss either your verdict or deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It's up to you to decide whether to preserve your privacy as a juror, okay? In other words, I don't want you to look up anything now, because in case something happens, but once the case is over, you are free to talk about it, but you're also free to never tell a soul about it. That is up to you individually, okay? I do have certificates for you. I do want to thank you for your service and wish you the very best, okay? If you could just exit out the door, but don't speak to anyone on the way out, okay? Mr. Cole, Mr. Parker, thank you very much, okay?
Thank you very much.
Carry it all.
Huh?
Carry all their stuff, so I
Okay.
have to do it all.
I don't know if they wanted their lunch or not. They both kind of took off. We can check with them real quick before they go too far.
Probably won't.
We can check with them real quick, see if they want their lunches. But otherwise, I want both attorneys to check with the clerk as to what is going back with the jurors.
Yes, Judge.
And will be otherwise adjourned as soon as that takes place. Thank you very much. Everyone did a very good job. I appreciate it.
Judge.
Okay.
Yeah, she already gave me all the other exhibits that we had. This is what exhibit is fine.
Just wanna make sure it's not really an evidence.
Tanya was sleeping with Eric. And remember, Eric's DNA, Wayne Walker told you, State didn't mention this, but Eric's DNA was on the passenger door, the rear passenger door of the Dodge Ram. But Eric Alvarado's exemplar was never sent to DNA International to determine if he was that at least one male contributor to the four-way mixture on the headrest of the passenger seat. No. We didn't do that. And the state also didn't send DNA International the inconclusive mixture from the driver armrest top or the bottom of the driver armrest from the Dodge Ram. Would those have provided a match to Eric? We'll never know because we didn't even try. As soon as Jose was determined to be the father of that child in this case, the case was closed. The investigation done. despite the fact that so many other people had the means, the motive, the intent, the opportunity, all of those things. So Eric's in this Waste Pro truck with Jose, allegedly talking about this murder, both before and after it happens. So let's talk about what Eric actually says. If you believe Norma and Rose, you can, at least the part that we heard, clearly hear at least some talking over each other, and it's not clear what they're saying or who is speaking, but let's talk about the quotes attributed by the government to good old Eric. And you don't have to trust me about this. You can ask for that play acting testimony to be played back again, so you can see which speaker was saying which part. Don't take my word for it. On set 3 of 39, on August 21st of 2018, Eric allegedly says, about. If we're to believe the state's case, Eric has no knowledge of any of this. How would he know that this person he doesn't even know, Tanya Wise, is saying anything? Jose, again, as attributed by the state's witnesses, then allegedly asks Eric, how did you do it? At night? And Eric says, yes. She said, and that was it. So Eric is killed before? Okay, good to know. Eric then allegedly calls the girl a damn bitch. Again, why? What girl? Who's he talking about? Why is he calling her names if he doesn't even know her? Eric then says he'll take something to Miami. What? If Eric's not involved in this, what's he taking to Miami? On set 8 of 39, on 8/23, Eric allegedly said, we need something like that, something with a barrel. Wow, okay, so Eric's talking about we need a gun. Why is Eric talking about needing a gun? Eric says, that's what I'm going to do. What's Eric going to do? Eric had nothing to do with this, right? If you believe the government, it was Jose and all Jose. What is Eric going to do? Eric, who's murdered before, apparently. On set 12 of 39, again on 8/23/18, Eric allegedly says, I'll probably go to jail. Well, what's Eric going to go to jail for if Eric didn't do anything?
Listening to the closing argument by defense counsel, bringing up a lot of other potential suspects, the defendant's wife, as well as his nephew, Eric, and several other people. We're going to have more of the defense's close when we come back. You can see the verdict clocks up there. We have Florida versus Swilley. They are deliberating there. And also we have the case we're watching, the closing arguments. We're catching you up on it, but they have been deliberating now for about 6 minutes. We'll be right back.
8.5 months pregnant, a young mother found brutally murdered.
To lose a child, there's no words for it.
Now the victim's boyfriend, a married father of 4,
is charged for the murder of his alleged mistress and her unborn child.
That's one of the things that struck me. He was not remorseful.
From the first gavel to the final verdict, Court TV takes you inside the South Florida courtroom
for this tragic death penalty case.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
what you don't know is that she disappears for 1, 2, and even 3 days. She just takes off recklessly to do her own thing. Is that good? She's gotten in trouble with me, with the police. She has a record. She's not the kind of person they'll be searching for like that. Nah, it could be after a week or 2 or maybe even a month.
We are in Florida this morning, where the fate of Jose Soto Escalera is now in the hands of a jury. The married father of 4 is accused of killing 23-year-old Tanya Wise, who was 8.5 months pregnant with his child. Prosecutors say when Wise refused to use the $500 Soto Escalera gave her to get an abortion, he told his nephew he had no other choice but to, quote, blow her brains out. Let's get you back to the courtroom now. We are a bit behind, so we can show you all the highlights from closing arguments, but you can see they have been deliberating now for about 12 minutes. Let's go in now for the remainder of the defense's closing argument.
On set 23 of 39 on 8/23, Jose allegedly says, like, clean it real good to take off all the fingerprints, all of them. Unintelligible, this bitch, unintelligible. If you got to use it, then you use it. Odd. If Jose's the one that does it, why is he telling Eric how to do it and what to use? If Jose's planning to do it, he would say, if I gotta use it, I'm gonna use it. Not, if you got to use it, then you use it. Who's you? Use Eric. Eric responds, I don't know what you're talking about. And Jose allegedly responds, exactly. Sounding like a guy who's done it before. On 8/24/2018, Eric allegedly said, this is the morning after the murder, mind you. Eric allegedly said, can't stop thinking about that. What's Eric thinking about? He wasn't even there, right? He doesn't know anything about it. What's he thinking about? Things that are running in my head. What things? That I should have, that I would have. Shoulda, woulda, what? On the morning after a murder that he was on tape planning a murder of something similar that he's done before? Should have, would have, what? That's their evidence. Those are their experts that say that say Eric said, can't stop thinking about that. Things that are running in my head that I should have, I would have. Then, interestingly, same day, Eric allegedly says, as soon as I walk in, she looks at me and she says, unintelligible, somebody else. Who is she? Who is she? Where did he walk into? With the female thinking it was going to be somebody else. That's curious. On 8/24/2018, Eric also allegedly said, I had it here, right here, this part here. You put in the output in this little thing, you put it, I put it right there and it all stays. What's he talking about? That's Eric. I'm not saying it's Eric. They told you it was Eric. Their witness told you it was Eric. What's he talking about? Later on 8/24, Eric like that. Now, everything to them, it's fine. To which Jose, again, these are the government's witnesses' attributions, not mine. Jose allegedly says, did she have a purse? Curious. If Jose was there and he's the one that did the murder. Or, let's assume he participated with Eric. He would know if she had a purse or not. He was there, right? He wouldn't need to ask Eric, did she have a purse? No. He wasn't there. It was Eric. Why is Eric, if Eric didn't have anything to do with this, doesn't know nothing about nothing, why is Eric? Someone says, I already took 2 baths when I got to her house. Whose house? No one took baths at Tanya's house. Tanya's mom testified. She never told you a gentleman came into my house and took baths. If the state believes that that's Jose, which I submit, I guess that's what they're saying, that it's Jose that says I already took 2 baths when I got to her house. Whose house? That's not what he would refer to his house. He would say my house. We know it's not Tanya's house because her mom didn't say, oh, a guy came in and took baths and it was weird. And we know Jose didn't go to another house, right? If you believe the state's witness about the cell phone, that witness didn't put him at another house. No, that's because that was Eric. Eric said that. There's no evidence at Jose's house when they conduct the search of Jose's house. Look, remember, they have all these fancy tools, right? They have all these things. They have that thing called Blue Star, right? They have Star Mix. They have all of these different things that can recover DNA. It lights up bright. Remember, they told you that. And this criminal mastermind is supposed to have gotten rid of every scintilla of evidence in his house. No, no. It's because he didn't do it. Eric did it. And the evidence is that whoever her's house is, but we don't know who her is because we don't get Eric Alvarado's phone records and we don't do a GPS location on his phone. So we don't know who her is, but we should have gone to her's house and tested there. That's probably where the bag is. You know, the bag, the missing bag. The state said, I wish we had found the bag. That's probably where the bag is. And in the bag would have been Eric's clothes covered in blood and Tanya's DNA. On 8/24/2018, Jose allegedly asked Eric, did you make it? Did you make the landfill? Inaudible, everything. And Eric responds, I hope so. Why does Eric need to go to the landfill on the day after the murder? Why is he hoping so? What's he got? Is it the bag? Is it the bag with his clothes in them? Was it Eric that took Jose's phone to lure Tanya out? And that's why there's a phone call back and forth? His nephew that he grew up with that sounds like him? And is that why when Eric says I walked into her house and she didn't know it was me, she wasn't expecting me? Because she thought she was meeting Jose and it was Eric, and Eric convinces her to come out, and Eric is driving Jose's truck? Because he says she looks at him and thinks he's someone else because she was expecting it to be Jose and not Eric. Does Eric's car have a Puerto Rican tag on the front? What even car does he drive? We don't know. There was no evidence of that. Or did he just use Jose's truck and remove the car tag like he talked about on that recording? That was Eric. On 8/25/2018, Eric allegedly says they're going to have questions. And Jose allegedly tells him, you're going to take my truck to my house. So we know Eric drives Jose's truck. We don't know what his car looks like. We don't know where Eric was that night or what his phone number was or where his phone was. But we do know his DNA was on the truck. And Eric believed he was fucked the morning after the murder. You should have doubts about the government's case. Those doubts are eminently reasonable. And you should find Jose not guilty. Thank you.
Thank you, Mr. Rizzo. Ladies and gentlemen of the jury, as I mentioned,
let's go ahead and bring in our guest for this hour to discuss. Joining us now from Pittsburgh, Pennsylvania, criminal defense attorney and former district attorney Matthew Mangino. Matthew, great to see you on this Friday. Matthew, I have to say, I mean, when this case was going on, I was thinking there's no way, what kind of arguments can defense counsel come up with here? But she is pointing toward a lot of people, the wife, the nephew, some other suspects, and she's going through all of this evidence saying there's a lot of doubt. What are you taking away from her closing?
Well, I thought her closing was very effective. When you think about the fact, Kelly, that they called no witnesses, and certainly the defendant didn't testify in this case. So this is their whole case, her closing argument. And I think she did very well in terms of creating or diverting the attention away from the defendant in this case. I mean, she pounded away at Deborah, she pounded away at Eric, and she did an effective job of making jurors think about, hey, why didn't they check for DNA of Deborah? Why didn't they check for DNA of Eric? Why didn't they, go and look at the surveillance and see if there's any other opportunities to find people? Why didn't they check the phones of these other possible defendants? I mean, it's a tough row to hoe. I mean, there's some evidence that puts Eric right there, and certainly his statements. But she did a nice job of trying to create some doubt.
Yeah, and so what she's arguing is that Eric could have been using the defendant's cell phone. Deborah could have been using the defendant's cell phone to lure Tanya Wise to them. She spent a lot of time, Matthew, really criticizing the translation of those audio tapes. We had Jamie White on yesterday, and he was saying that he didn't even think that the prosecutors really needed those, and we kind of went back and forth with that. I was saying, as a prosecutor, I would want to use them, and he said you should use them, but you didn't have to focus on them as much. Defense counsel really ripped those apart, saying you can't trust those translations.
Well, yeah, and again, she is making an argument to this jury that these transcripts are not completely reliable. You can't rely and put a person's life in jeopardy, because there is the potential for the death penalty here, when in fact these don't seem to be completely reliable translations. And so I think she effectively has turned that on the prosecution to say, hey, don't necessarily, put all of your eggs in one basket with these translations. They may not be accurate.
Yeah, exactly. That was very, very effective to maybe not get that first-degree murder. So we'll see what happens. We're going to have the rebuttal coming up next. Matthew's going to stick around with us. So that rebuttal's coming up in this death penalty case for Jose Soto Escalar. You can see they are deliberating already, but we're catching our viewers up on the closing. Rebuttal is next. Stay with us. You're watching Court TV. I'm Kelly Craft. In today for Ted Rowlands. Back to Florida, where we have been watching closing arguments. This is in the pregnant mistress murder trial. Jose Soto Escalara faces the death penalty if he is convicted of murdering his pregnant mistress. Her name is Tanya Wise. According to court documents, the body of 23-year-old Wise was found face down in a roadside drainage ditch back in August of 2018, and she was 8.5 months pregnant with the defendant's child. Let's go back now into the courtroom. This is the state's rebuttal close.
We want to view things, number one, through the lens of the jury instructions. But number two, and just as significant, we want to view them through the lens of common sense, right? We never, ever check our common sense at the door in any criminal case or really in any walk of or aspect of our lives. So let's take a look and consider what counsel just said using that common sense. So they first told you that the defendant's wife killed Tanya, okay? Or at least had a role in it. Well, let's think about that for a second, and let's use our common sense and use the evidence. So you might say, well, why would, first the reason is, why would she commit these killings? I mean, if you're going to kill a pregnant woman, it seems like you would have to have a pretty good reason to do that, right? You'd have to have a pretty good reason. Well, you may say, well, wait a second. Well, maybe she did, you know, maybe she found out that Tanya had slept with Jose Soto Escalara, right? I suppose that would give her at least some motive to kill her. But if that were true, then why would Jose lie to the police about impregnating Tanya, right? Why would he lie to the police about impregnating Tanya if she already knew that she was pregnant by her husband? That doesn't make sense. The wife did not know that defendant had impregnated her, because if she had known, then he would have simply said that to the police when he was interviewed on August 25th of 2018, right? So that doesn't make sense. So we can rule that out, right? We can flatly rule that out, what the defense said. So then they say, well, wait a second, maybe Eric Alvarado did it, right? Maybe Eric Alvarado committed these crimes. Well, if you recall, remember, Eric Alvarado also has no motive to kill her, right? He's not the father of the child. There's no evidence that Eric Alvarado had ever had any type of relationship with Tanya, let alone sleep with her.
Ladies and gentlemen, there's an objection as to this point. There's a dispute between the lawyers. You're the finders of fact, and you get to decide which side is accurate as far as what the evidence is. So I'll overrule the objection, but leave that to the jury to sort out.
Okay. So anyway, so he had no motive to kill her, and more significant, if you recall, in the August 24th translation with Rose Rosario, what does he say? Well, Eric Alvarado asks him about the blood. Did you see blood? Did you see blood? Had Eric Alvarado been there and been involved in this, he would have had no need to ask that question. He's asking the question because he doesn't know the answer. So we can rule Eric Alvarado out as well. And you also have to ask yourself, well, wait a second, you know, the truth is, it never changes, right? I mean, the truth never changes. Well, if this were legitimate, then why are they offering you all these alternative theories? So the defense counsel also made the argument, well, wait a second, why didn't a court interpreter come and testify and translate the videos in real time, right? Why didn't they do that? Because the court interpreter is neutral. The state hired the FBI. The state hired a private interpreter. Why would they have done that? Well, there's a very good reason, and the reason, of course, doesn't come from me. The reason doesn't come from the words of the attorney, because what the judge told you, and what the judge told you right before I got up for my first closing argument is, what did he say? The words of the attorneys are not evidence, right? The words of the attorneys are not evidence. The evidence comes from the exhibits and what's said here under oath by the witnesses in the case. So let's fall back to the evidence, right? Let's fall back to the evidence. What is the evidence in this case? Rose Rosario, and I asked her, what is the difference? Tell us the difference between a translator on one hand versus an interpreter on the other. What did she say? She said, listen, there's a large difference, right? A large difference. Translators use documents and recordings. Translators have the luxury of being able to sit down and to sift through recordings and sift through evidence to make sure that they get it right, which is why that they expended so much time on the work that they performed. They have the ability to sit down and listen through it, and as both Norma Campos and Rose Rosario explained, they listened to several sections multiple times, and used, and in fact, I think 50 hours for Norma, 50 plus hours, and 100 plus hours for Rose Rosario. So they have the ability to do that, and that's what they did. Why do they do that? Because they can ensure accuracy, and they can go and re-listen to things, and they can also take into account the context of what is being said, right? Very important. Interpreters don't do that. Interpreters translate in real time. They work in real time, and they don't have the luxury of being able to refer to other parts and being able to ascertain meaning from words in that regard. So bear that in mind. Reasonable doubt. Okay, so let's talk about this for a second. Defense counsel says, well, wait a second, there's all kinds of reasonable doubt in this case. And what did they do? They pointed to two errors.
Listening to the rebuttal by the state. We have some more of it coming up, but we're going to squeeze in a quick break. We'll be right back.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
It has been 7 years since the body of 23-year-old Tanya Wise was found in a ditch off of a rural road. Now, the father of her unborn child, Jose Soto Escalara, is facing first-degree murder charges in her death. Investigators say that the defendant gave Tanya money for an abortion and that he became angry when she did not follow through with it and then kept the money. Let's go back into the courtroom now. This is more of the state's rebuttal.
Errors, right? 2 errors within reports. So remember, the criminal justice system is no different than the areas where you work at, in that people make mistakes, right? People make mistakes. There is no such thing as perfection, right? Just because we haven't presented a perfect case doesn't mean that we haven't proven our case. There is no such thing as perfection, and the criminal justice system is no different. Defense counsel points out, well, wait a second, there is a typo in Dr. O'Neill's report regarding Josiah's age. The OBGYN.
Facts and evidence.
As to this point as well, there's a dispute as to the facts of the case, and ladies and gentlemen, you're the fact finders, and you would resolve the dispute, but I'll overrule the objection and leave that to the jury's determination.
Okay. The OBGYN, Dr. Stossel, said the child was 32 or 33 weeks along. Dr. O'Neill said 36 or 38 weeks along. There was a several week difference. Okay, right? Dr. Stossel is going to be more accurate on that point, meaning that Dr. O'Neill had made a mistake when she had simply gone through those medical records. Does that really amount to reasonable doubt, right? Does that really amount to reasonable doubt? Does that give you any reason? Does that give you any reason to think that Dr. O'Neill got the cause and the manner of death wrong? Of course not. Was Dr. O'Neill wrong when she said that Tanya died of a head injury, which caused a skull fracture and brain swelling? Was she wrong when she said that Tanya died of 2 significant, serious sharp force injuries to her neck? No. No. We're talking about a typo in her report, or a mistake in her report. Is that reasonable doubt? Of course not. Of course not. There is no requirement. There is nothing in those jury instructions that the judge read to you. There is nothing in the jury instructions that will go back with you that suggest or even approach this standard of perfection that they're wanting you to employ.
Objection.
There is no.
You could approach on comment.
Lots of objections during the rebuttal. Let's bring in criminal defense attorney and former district attorney Matthew Mangino. Matthew, they're just on a really short break there, but I wanted to bring you in on this. A lot of objections from defense counsel. She is not liking some of the things that she said. For instance, she said that the nephew was having sex with Tanya Wise. He then said that Eric was not.
Well, yeah, I mean, so that is subject for argument in terms of how you present the evidence that's been presented in the case. The objections, I think, are suggesting that what was being argued by the prosecution wasn't in evidence in this case. It's unusual to see objections during closing arguments. Sometimes that distracts the jury, which could be effective for the defense. Sometimes it makes them mad. So you have to be careful how you approach objections during closing arguments.
Yeah, from an attorney's perspective, when you keep hearing objections when you're trying to deliver your close, it really kind of ruins the flow. And you, personally, I never liked that. So that sidebar's over, Matthew. Let's go back in and hear more.
I'll ask you to not consider what was just said, and I've instructed the prosecutor to restate it consistent with the instructions I've given you. You may proceed.
So the point is, there are always conflicts in evidence in any case. The question is, do they rise to that level of reasonable doubt? And of course, the answer to this is no. Defense counsel also pointed out, well, wait a second, there's another typo in the Rose Rosario's translation on her certificate. She translated the August 24th video, and on her certificate she wrote August 23rd. Does that rise to the level of reasonable doubt? Does that rise to the level of that, those two typos, that's what you're being asked to consider? That? Two typos in two separate reports, that's reasonable doubt? If you recall from jury selection, what I asked you to do is to not simply hang your hat on one or two items of evidence. If you recall from jury selection, I asked you to consider all of the evidence, right? Not just to hang your hat on one or two pieces. That's what and that's what we're asking you to do, to make sure that we could render a true and fair verdict based on the law and the reasonable doubt instruction. Remember, the defendant is the only witness in this case who had a motive to kill Tanya and her child. No one else. And remember, frankly, we are not here to play the lottery with the evidence in this case, right? We look at this, we look at all of this through the lens of reasonable doubt. We know the defendant is the only witness in this case with a motive to kill her. The defendant is the only witness who had an opportunity to kill her, right? He's the only witness who had an opportunity to kill her. The defendant's the only witness who was with her on the night of the murder, and he spoke to her on the phone. And he's the only person who planned out her murder and then executed it based on what we know from the translated transcripts by both Norma Campos and Rose Rosario. Ladies and gentlemen, there is no reasonable doubt in this case. There is no reasonable doubt. All of the evidence, when taken in totality, all of the evidence, when considered by fairly and objectively and through the lens of the reasonable doubt instruction, all of it points to this defendant and this defendant alone as to who killed Tanya Wise and her unborn child. On behalf of Tom Backendall, your state attorney, I thank you for your patience and your service today. Thank you so much. Thank you.
Thank you, attorneys. Members of the jury, yesterday...
All right, that concludes the state's rebuttal. Let's bring in Matthew Mangino. Okay, Matthew, don't have tons of time here because we're getting close to the top of the hour, but maybe just give me your thoughts on the rebuttal. From my perspective, it's just because of all those objections, I feel like the defense's close was very strong. And usually in the rebuttal, as a prosecutor, you can really, hammer home a few points. I think just he got interrupted so much, it wasn't as effective as it could have been.
Yeah, it did make his rebuttal seem to be a little disjointed. But the thing that I found about the rebuttal is what I didn't hear. There wasn't much addressed to why wasn't Deborah more thoroughly investigated? Why wasn't Eric more thoroughly investigated? Why were there DNA samples? All those kind of things that we heard from the defense. We didn't hear that in the rebuttal. And to me, that's a bit of a concern. They focused in on some typos, but the main arguments they missed.
Great point, Matthew, because he could have said they weren't investigated. Deborah wasn't investigated because she didn't do it. Eric wasn't investigated because he didn't do it. He missed an opportunity there. Excellent point, Matthew. Coming up, we're going to switch gears and head to the other live trial out of Florida and get you caught up on the closing arguments in the dosed and choked murder trial for Herbert Swilley. And you'll notice that verdict clock is stopped. The jury has a question. We'll get you caught up on all that coming up next.
There's no obligation. 1-800-709-6100. Call now.
This is Court TV Live. I'm Kelly Craft in today for Ted Rollins. Happy Friday to all of you. We are in Florida this afternoon. We are in a double verdict watch for 2 murder trials. In Fort Pierce, Jose Soto Escalara is facing the death penalty if found guilty of murdering his 23-year-old pregnant mistress. The jury has been deliberating now just for a short bit in that case, nearly an hour though now. It will take you into that courtroom as soon as there's a verdict. But we want to begin this hour in Florida also. This is Ocala, Florida, where the fate of Herbert Swilley is now in the hands of a jury. He is accused of drugging and then strangling his husband, Tim Smith, and then staging his murder as a sexual encounter gone wrong. You'll notice the verdict clock there has stopped as well. The jury came back a few moments ago requesting to see some body camera footage along with several other questions they had about the investigation. So we'll get you into that courtroom as soon as there's a verdict there. But for now, let's get you caught up on highlights from closing arguments earlier today. Let's go in now for the start of the state's close.
There's been quite a bit of evidence in a lot of cases, so thank you for that. This is Tim Smith. Tim was happy. He was successful. He was kind. He was involved in the community. He was loved by everyone. Tim was everything that the defendant was not, and the defendant couldn't stand it. And when Tim decided he was finally going to leave the defendant and move to DeLand and get a new job, the defendant was so angry. He told everybody, if Tim thinks he's leaving me and moving, he's got another thing coming. He thought Tim owed him. He was not going to let Tim leave him that way. So instead, he brutally murdered him. This is a case about death by 1,000 cuts. And what that means is that there isn't one big piece of evidence or one big witness, but the accumulation of many seemingly small pieces of evidence, when put together, become devastating, and they result in the overwhelming proof of guilt. That's what this case is about. The defendant thought he was smarter than everyone. When Darrell Levine asked him, "Did you do this?" he didn't say no. He said, "No one is ever going to be able to prove it." But guess what? He hadn't met Sergeant Pinder and the other detectives from the Marion County Sheriff's Office, because they worked tirelessly for 8 months to prove this case. And remember all the things they told you they did. The detectives canvassed both neighborhoods where the apartment was and the residence was numerous times. They dug through the trash at those places. They knocked on every door and tried to collect every piece of video that they could. Other detectives went to every single business on the street between the apartment and the residence. They dug through the dumpsters there looking for evidence. And they got every single piece of video footage that they could. And then for the next several months, Sergeant Pinder reviewed all of that video footage. And think about how much video footage that was. I mean, they were asking for a span of 12 to 24 hours. He reviewed every piece of that until he found the defendant's truck and Tim's Jeep on that. So in the end, the defendant was wrong. We can prove it to you, and I'm going to show you that this morning. The defendant's charged, as you know, with 1 count of first-degree murder. And the judge read this to you, and this is in your jury instructions. This is what we have to prove to you before you can find the defendant guilty of first-degree murder. Now, you also heard in the jury instructions, there's what's called lesser included offenses. So even though this is what's charged, you will have two other options: second-degree murder and manslaughter. But the judge will tell you, you have to find the defendant guilty of the highest charge we have proven to you, which I submit to you is first-degree premeditated murder. The elements of second-degree murder and manslaughter are in your jury instructions. Second-degree murder would be if there was no premeditation, and the defendant and Tim just had a big fight, and the defendant killed him. Manslaughter is if the defendant didn't intend to kill Tim, but he did an act which killed Tim. Neither one of those apply to the facts in this case. And when you look at the elements of first-degree murder, you won't need to go any further to even look at the second-degree murder or the manslaughter. Now, as you see, there's three things, and that's it. These are the three things that we have to prove to you for you to find the defendant guilty. Number one, Timothy Smith is dead. There's no question there. That was stipulated to. That's Timothy Smith, and he is dead. The defense is stipulated to that. Number one is crossed off. That's proven beyond a reasonable doubt. And I want to skip to three, the premeditated killing of Tim. Was it premeditated? And I think a lot of people have the wrong conception of what premeditated means. This is the definition of killing with premeditation. It's killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. And what this means is there is no amount of time that has to be present. It doesn't have to be an hour before he decided he was going to kill Tim, the day before, or the week before. The only thing that has to happen for it to be premeditated is he decided he was going to kill him, and he had time to reflect on it and do it. That's what this says. There is no fixed exact period of time. That is what the law in Florida is, for you to find him guilty of premeditated murder. And I know we see a lot of shows on TV, and they make lists, they plan it for a while. And even though he did do that here, there is no set amount of time for premeditation. Now, how do we know it was premeditated? We have two different ways we know. One is the diphenhydramine. Tim did not take the diphenhydramine. The only way he got the diphenhydramine was from this guy right here. He had 30 times the amount of a normal dose of diphenhydramine in his system. We know he had a big interview the next day. There's no way he took that on his own. And he's the only person that could have given it to him. And the only reason that he would do that is so it would be easier for him to kill Tim, and Tim couldn't fight back. And that's why he did that. That's the only reason he would give him the diphenhydramine. And that clearly proves premeditation. But even if you don't think that he gave him the diphenhydramine, or you have questions about that, the manner in which he killed Tim proves premeditation. And that's because of a strangulation. That's a prolonged, tightening, squeezing, remember, until he broke his neck. When you are doing that, it takes some time. And Dr. Corey said that mark was so defined and dark that it had been on there a while. During that time when you are doing that and you are squeezing, you intend to kill Tim Smith. There's no way you don't intend to kill Tim Smith during the time it takes to strangle him. That is premeditation. Fits the exact definition of premeditation. And also, it's not just strangulation. We have two separate acts. He not only strangled him in the most horrific manner, he beat him in the face. I mean, multiple blows, multiple. You had the left eye, you had the right eye. I mean, during that time frame of beating him in the face, the time it takes to go get the ligature, whatever it was, maybe he had it next to him. He had to consciously pick that up, put it around Tim's neck, and then start squeezing it. There is no way you can say that he did not intend to kill Tim Smith and it wasn't premeditated. For both of those reasons. This is clearly a case of premeditated murder. He didn't just all of a sudden snap and say, oh, I'm gonna kill Tim. And that's 3. So now we've met 1, Tim is dead, we've proven that beyond a reasonable doubt. Is it premeditated? Sure. You have 2 different ways it's premeditated. Pick which one. They both apply in this case. What does that leave? The death was caused by the criminal act of Herbert Swilley. That's the last thing we have to prove to you, is that this guy did it. I first want to talk about the defense witnesses before we go into our evidence. We heard from Amy Counts. She said she heard a child or a person screaming Friday night in the general direction of the apartment of Tim and the defendant's apartment, which is 3.5 blocks away. Thanks for the testimony, Ms. Counts, but Tim was already dead at that point. We know Tim was dead Friday evening, around 11 o'clock. Remember that there had been no use of his phone after 9:45 on Thursday. He didn't go to work, nobody had seen him, he didn't reply to a text, he didn't reply to a call. And by the time they found him Saturday, he had already started to decompose. So, Amy may have heard some...
Listening to the state's closing argument in the Swilley case in Florida, we are going to squeeze in a quick break, but don't go anywhere. We're coming right back. You're watching Court TV Live, your front row seat to justice.
8.5 months pregnant, a young mother found brutally murdered.
To lose a child, there's no words for it.
Now the victim's boyfriend, a married father of 4,
is charged for the murder of his alleged mistress and her unborn child.
That's one of the things that struck me. He was not remorseful.
From the first gavel to the final verdict, Court TV takes you inside the South Florida courtroom
for this tragic death penalty case.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
Well, welcome back to Court TV Live. I'm Kelly Craft. We already have a verdict in the Jose Soto Escalera case. You can see the verdict clock is stopped just over an hour. That's all it took them to come up with a decision in this case. Let's go ahead as we wait for them to make their way into the courtroom and bring in our guest for this hour to discuss. Joining us now from New York City, trial attorney Cannon Kearney. Hey there, Cannon. Nice to see you on this Friday. Okay, it didn't take them very long. We don't know what the verdict is yet. As soon as we have it, and as soon as they start making their way back into the courtroom, we're going to take that for our viewers live. You're taking a look inside that courtroom right now. But Cannon, just give me your thoughts as we await the verdict in the Soto Escalera case.
Well, happy Friday, Kelly. We're seeing a very, very, very quick verdict. So this, more likely than not, cannot be good for the defendant. If I was a defendant, I would be thinking to myself, I mean, he's already stressed about what the verdict is going to be. But now that we have such a quick verdict, I would be thinking this can't be good for me.
Yeah, I mean, that top charge, first-degree murder, Cannon, defense counsel, really, I will say, I did think that her closing was pretty effective, trying to point the finger at other suspects. But if they went back there and were discussing other suspects, I would have to suspect it would take them a lot longer to come up with a decision in this case.
Agreed. I would say that the information that was provided from his work truck, the transcriptions or the transcribing, that probably was the nail in the coffin for him. You know, it pretty much takes away any credibility that he has as a great human being, a outstanding person in the community when he's discussing how he would kill the woman or the victim who ultimately ended up dead.
Cannon, you mentioned those tapes, those recordings. So he was a dump truck driver. He was being recorded, and there were video cameras all around in the truck, and we heard testimony as to why they were there. They wanted to make sure that their employees were not driving recklessly, weren't driving in unsafe conditions, weren't texting and driving, so they knew they were being recorded. Defense counsel tried to argue if you knew you were being recorded, you really wouldn't be talking about this stuff. She tried to say those weren't what the translations were. The way they were translating them were actually not accurate. That's what she tried to say. But let's go ahead and play this one part, which I think probably was pretty convincing for the jury. Again, we don't know what the verdict is yet, but let's go ahead and play that.
And I'm not the only one. She's pregnant from that little that works there. She says it's mine, supposedly. I can't take chances. I lose everything. No, I am telling you the truth. If something happens to me, you already know. I'm going to blow her brains out so she doesn't talk. I have to do it, Eric. I have no other choice. I'm going to lose everything. What I need is someone to drive me. That's it.
All right, Cannon. So you heard these translations right there. And I will say, before defense counsel delivered her closing, I thought, oh my gosh, what is she going to talk about? And again, I do think she did as good of a job as she could with what she had to work with. But you hear the translations of those. I mean, that is just, I mean, it's pretty horrific.
It's horrible, Kelly. I mean, you have someone here who's obviously very concerned about what this information will do to his life. Well, we now subsequently know that he was married. We know that he had a family of his own. So this young victim wouldn't have been someone that would help him or make his life easier. So based on that transcribe of what was said in the car or in the truck, it's clear that he wanted this problem to be taken care of and that he would do whatever that it took in order to take care of it. So unfortunately, the defense didn't provide any transcribings of what they assumed that he was saying other than what was actually provided. And I believe that the jury heard that, and now we have a quick verdict.
Yeah, what she was just trying to argue is that just their translations were not accurate. But not only did he have a family of his own, he also had a little baby growing inside of his mistress, who she was 8.5 months pregnant. And I believe she was scheduled for a C-section the very next week or something really close to that time frame. So, yeah, I just don't think that it looks very good for the defendant. in this case. We're going to get in a break, Cannon, but what we're hearing also is that if they come back on that top charge of guilty in first-degree murder, then we're going to go into the penalty phase. But the penalty phase, they discussed this, it's not going to be taking place until next week. So that wouldn't be taking place, if we go there to the penalty phase, until next Wednesday. We're going to squeeze in a break. We'll be right back. Welcome back to Court TV Live. Breaking news in the case we have been watching out of Florida. This is a verdict in the Jose Soto Escalara case. What we're hearing so far from our producer on the ground there in Florida is that the defendant has just been making his way into the courtroom now. We're still waiting for the judge to take the bench. So as soon as the judge does, and we have audio from inside that courtroom, we will take you there live. But as we wait for the verdict, let's bring in trial attorney Cannon Curdy. So Cannon, let's just talk talk. We have the verdict that we're awaiting. We do not know what this verdict might be. When taking a look at this case and all of the evidence against the defendant, is there anything differently you think the defense counsel could have done? They didn't present a case, but she did make a heck of an argument in closing arguments, pointing the finger at other people, saying someone else could have been driving that truck. Somebody else could have been texting and calling from the defendant's cell phone.
Kelly, I just believe she's, did a Hail Mary in this situation, because at this point, who is that someone else? What pertinent facts does she have that would assist the jury in believing that this someone else actually committed the crime that the defendant is here for today? So I don't see much that's going to be able to assist him, especially considering the fact that there are facts that he provided her with money for the deceased victim, with money for an abortion, and that she allegedly didn't use that money for what he paid her for. So all of these different facts are, if I'm a juror, just essentially sealing the coffin at this point for the defendant.
So, Candace, when we talk about the victim in this case, 23-year-old Tanya Wise, defense counsel really in the closing talked about her background. She knew some people that were not the, most maybe upstanding people in society, and she even pointed to her own client, saying he's not either. Yes, he was cheating on his wife, who he had been married to for a number of years. So she was really talking about the victim. That's a fine line to walk when you're delivering the closing, when you have a situation where this poor young woman, she was pregnant, 8.5 months pregnant, and she was found face down in a ditch. I mean, you got to be careful, because she died a very tragic death, and she was a young pregnant mother. That's hard to do, but defense counsel does have a job to do in defending her client.
You're correct, Kelly. So essentially, the concern with walking that tight line is, does someone in the jury have an affinity with pregnant women, or women who are going to be mothers, or women in general? So if they do, and they have an issue with you now victimizing the victim, making the victim into a bad person, then that in itself could stop them from hearing anything else that you have to say. It's a very tight line. At the end of the day, you have to advocate for your client. You have to persuade the jury to acquit him in this situation, and you want to use every fact at your disposal to do that. It's just many times when you go after the victim, jurors don't like that. They are not going to be able to hear much more many times when they have just made in their mind that this person has been wronged, and we're here solely to go after the person who committed that wrong.
Yeah. Let's go ahead and play a little bit of a clip. This was during the trial, and this is the defendant, a translation of the defendant, in which it appears he's saying there's no evidence for them to find that maybe he committed this crime. But let's go ahead and play it. We can talk about it on the other side.
Because I have to be calm like that now. Everything to them, it's fine.
Did she have a purse? Hers? No. If they find her now, they can't do the inaudible final, because the mom is not called. She is not missing yet on this side. They don't consider her as missing. The what did she die of? What did she have? What does she have? So they will put her in a box, take her out, the son, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths when I got to her house, and I bathed this morning. I bathed. I cleaned my hands with the cleaner, the one for breaks, because I had gloves and everything just in case.
Did you see the blood?
Huh?
Did you see blood? Did you see?
I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag.
I mean, Cannon, talking about those translations. I mean, you hear those, and it's just like, ooh, how can the defendant even, sit there? Obviously, they have a right to remain silent. They don't have to say anything in a case. He didn't take the stand, which was a good thing. What do you make of that?
I mean, it's damning. This is someone that appears to be discussing how he got rid of evidence. This is someone that appears to be discussing how he's eluding the police and investigators and law enforcement. So again, the only thing that I could see that would make any sense for the defendant to fight this would be that he's going after what is perceived to be said in a foreign language. That's it. The transcribing is wrong. So bring someone in that's going to provide a different translation of what was said in the truck or when he was recorded. But besides that, if we're going off that these are legible, these are from someone who was accredited with putting their stamp on this being the correct translation, then I don't see how he's going to escape a guilty verdict.
Yeah, I'm with you on that. We're taking a live look inside that courtroom now, just waiting for the judge to get on the bench. You can see the security guards that are lined up in front there. This always happens in pretty much every case that I've been involved with, just because they need to make sure that no one has any outbursts or no one does anything that, could cause any challenges inside that courtroom. Cannon, I was taking a look at the jury makeup. So obviously some are alternates, but there were 16 people, so 12 would be deciding the case, then 4 others as alternates. It looks like, if I'm looking at the jury makeup correctly, it looks like there are 13 women and then 3 men. Now, of the deciding panel of 12, who that is, but I believe 3 men are on that deciding panel, so then that would leave you with at least, the nine females. From a female perspective, and I'm a female, I mean, you hear this case, you hear the evidence in this case, you hear the young woman, and she's, obviously having a relationship with a married man. She's pregnant with his child, and she dies this terrible death. She's about ready to give birth to, another child. I mean, women don't look too favorably upon that, I have to tell you.
I would say you always want to look at the jury makeup. So at this point, with the makeup being 13 women and 3 men, you want to know, what did the defense voir dire? What happened during that time period? Why weren't there more men? What is the age range of the women? All of these different things will come, obviously, to matter when we get that verdict. But again, this goes back to now making the victim into the bad person. If you are speaking to the jury, who again is comprisely made up of women, then as you just indicated for yourself, Kelly, that's something that you're not going to look favorably to. So I just don't see, again, it makes a lot of sense why we have a verdict after an hour. Obviously, I'm not a soothsayer to say that it's guaranteed to be a guilty verdict, but based on the facts, based on the jury makeup, based on everything that I've heard, it's no way possible that it's not going to come back guilty.
Yeah, and it looks like it's 6 Hispanic women and 2 Hispanic men make up that panel. Obviously, the defendant Hispanic as well. So we have another clip, Cannon. Let's go ahead and play that. We can talk about that one on the other side.
What you don't know is that she disappears for 1, 2, and even 3 days. She just takes off recklessly to do her own thing. Is that good? She's gotten in trouble with me, with the police. She has a record. She's not the kind of person they'll be searching for like that. Nah, it could be after a week or 2, or maybe even a month.
And Cannon, that one really bothered me when I heard that one too, because it's like, here's this person basically saying this young girl doesn't matter. who knows what her circumstances were growing up, and obviously she was involved in a lifestyle that, people don't look too favorably upon. And, and then he's basically just saying, oh, no one's even going to look for her, no one cares for her. And again, we don't know what the verdict is in this case. I'm just talking about in regard to just hearing the evidence as a juror, and you hear that someone was saying that, that's what they're saying, he said it, it just doesn't sit well.
It doesn't sit well, Kelly, but to be truthful, of all the things that I've heard, that horrible translation actually would have been the best. Had he not had other translations where it was discussing him murdering and getting rid of the bloody clothes or whatever it may be, this one actually may be helpful because he's discussing solely her background. He's discussing that she has gone missing before and that had nothing to do with him. So again, this is something that you're trying to find the best out of the worst, or make lemons into lemonade from lemons. But at this point, that would have at least been able for him to be able to say, she has a background that I don't know anything about.
Yeah, no, that's true. Looking at the defendant there, awaiting his fate, adjusting his suit coat there, unbuttoning it, because he's going to be having to stand up here pretty soon to see exactly what the jurors decide. We're going to take a break, Cannon. Stay with us, viewers. We're coming right back with a verdict in the case we're watching out of Florida, the pregnant mistress murder trial. We'll be right back.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Martell ever walked on. It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
Welcome back to Court TV Live. We are waiting a verdict in the Jose Soto Escalera case. What we're hearing is that the judge has made his way into the courtroom. We're still waiting for some jurors who are finishing up their lunch. That's what we're hearing from our group on the ground there. So as soon as we have a verdict in that case, we will take you there live. But in the meantime, we still have Cannon Kearney with us. Okay, Cannon, just talking again about some of the things defense counsel said in closing, and she was pointing the finger at Deborah, who is the defendant's wife, talking about that, also talking about the nephew, saying Eric could have done it as well. But it's just really interesting to hear then when you see all of this other evidence and nothing really concrete that pointed to Deborah or pointed to Eric. Now, what defense counsel was saying is they didn't really fully investigate these two other potential suspects, and that's what defense counsel has to do. But there really wasn't any evidence to point to them during trial.
Well, definitely no evidence, Kelly, to overcome the cell phone pings that indicated that the defendant was moving to and from the area in which the victim was. Definitely no evidence to indicate that the carpet that had the victim's blood on it from his car, from the defendant's car, that doesn't point to the wife, Deborah. So even if they were able to, quote unquote, speculate about other individuals who may have done this horrendous crime, the facts still lead to the defendant. And even if they didn't, again, now you're looking at the totality of facts. So you're going to go into the recordings. You're going to go into witnesses who've described their conversations with him in regards to the victim. So he's not being painted as somebody that, as a juror, you're just going to say, well, you know what? It's not enough evidence. I'm just going to say he didn't do it. No, they're going to say he did it, and most likely that's what we're going to hear when the verdict comes. Guilty.
Ken, and what about this one that defense counsel argued in closing? She said what we heard on those recordings is that the defendant is talking about a gun. We heard him say it, according to the translator. I want to blow her brains out, or something along those lines. The defense counsel said, but that's not how she died. She had 2 major injuries to the top of her head. So she died of a head injury. So defense counsel was saying, well, he was talking about using a gun to blow her away.
At some point in time, maybe that was what he was thinking of, how he was going to dispose of or to murder the victim. But even in that clearly indicates the thought process or the character of the defendant. So that the victim didn't die that way doesn't mean that he wasn't the person that killed her. It could be, one right, one wrong, or 2 of the same things that are right, but it just didn't happen in the way that the defense is trying to paint the picture. So I would say that his character is shown more so from those conversations, and that's what's going to affect the jury more so than the actual manner in which the victim died.
So we're still waiting for them to read the verdict, to make their way back into the courtroom, the jurors. So why don't we do this? Let's play back some key testimony. This is the victim's mother. So Tanya Weiss's mother, she was on the stand talking about, it was the night, I believe it was the night before they found her body. Let's go ahead and play that.
I want you to go ahead and describe Tanya for us. So first, way back on August 23rd of 2018, how old was Tanya?
She was 23.
I'm sorry?
She was 23.
Okay. And did she have children?
Yes. At home, she had an 8-year-old, Jamar, and she was pregnant.
Okay. How far along was she in her pregnancy?
She was about 8.5 months.
Okay. And had Tanya decided on the name of the baby?
She decided that on the baby shower. It's Josiah Thomas Weiss.
Okay. A boy?
A boy.
Okay. And did she live with you on August 23rd of 2018.
Yes, sir.
Okay, where did you guys live? What was the address?
2014 Southwest Larchmont Lane in Port St. Lucie.
Okay, is that located near Bayshore Boulevard?
Yes.
Okay, and is there like a is there a Winn-Dixie close to that area?
Yeah, if you continue the road, it's 2 blocks down. There's a Winn-Dixie.
Okay. Do you remember her phone number?
I believe so. It's 772-607.
Okay. And did you pay for her phone, or did somebody else pay for it?
Bradley paid for it.
And what's Bradley's name?
Bradley, I think it's Rodriguez. I'm not sure if Rodriguez or Hernandez, one of the two.
Bradley Rodriguez?
Uh-huh.
Bradley Rodriguez Jr.?
Yes.
Okay. So let me go back, and I want to focus you in on the events of August 23rd, 2018 in the evening time. Do you remember that time?
Yes.
Okay. Go ahead. What were you doing around 8 in the evening on that day in your house?
Me and my daughter, Tanya, we had given her son a bath because he was going to school. So we gave him a bath around that time always. And I had him, I was going to get him dressed. She was going to go out. She needed to get drinks because he didn't have no drinks for lunch the next day.
Okay. And did she, about what time did she leave?
It's probably about anywhere between a little bit after 8. I mean, I said a little bit. I mean, I didn't exactly look at the clock, but I know it was a little bit after 8. Could have been 8:15, 8:20. It was around that time.
Okay. Okay. And when she left, where was she going again? I couldn't quite hear you. I'm sorry.
She was going to go get drinks for her son for school for his lunch.
Okay.
That's the purpose she left the house, because she had problems walking and everything because of her pregnancy. So she left just to get the drinks.
Okay. And was that the last time you ever saw your daughter Tanya?
Yeah, by the door. Yes.
Okay. And are you aware if Tanya had a follow-up doctor's appointment the following week?
Yes, it was a Tuesday for her.
All right, we're going to get out of that because we're hearing there's movement inside that courtroom. We were just replaying some testimony from Tanya's mother when she had taken the stand earlier in this case. Her mother is sitting there, of course, waiting to hear the verdict, waiting to see exactly what the jurors come back on in this case that's against Jose Soto Escalara. But we're just waiting for everyone to make their way back into that courtroom. I don't believe that we have any audio yet. We don't have any audio yet, so still kind of waiting for things to take place. But as we wait, oh, he's standing up. Let's go ahead and go in.
Back on the record, all parties are present. Hold off the jury. I'm told the jury has reached a verdict. Before we receive the verdict, particularly in this case, it's imperative that whoever remains here in the courtroom while we receive the verdict remains stoic and does not express himself or herself with joy or sadness or whatever it is, because there's a potential that the case continues, and that would be improperly influencing the case going on. So if you're here, make sure you can contain yourself and do not react whatsoever when the verdict comes in. If you cannot control yourself at this time, please leave, and someone else will tell you what happened. Is everyone clear on that? All right. Let's bring in the jury, and we'll receive the verdict. Please hand the verdict form to the bailiff. who will hand it to me for review before it's published. The verdict is in proper form. The defendant shall remain standing while the verdict is published through the clerk.
We, the jury, find Jose Soto Escalera as to count 1, guilty of first-degree murder as charged in the indictment. If you find the defendant guilty as charged or guilty of any of the above lesser offenses, you must next determine if any of the following has been proven beyond a reasonable doubt. Check yes if proven beyond a reasonable doubt. Check no if not proven beyond a reasonable doubt. During the commission of the offense, the defendant did carry, display, use, threaten to use, or attempt to use any weapon. Yes. As for count 2, guilty of first-degree murder of an unborn child as charged in the indictment. So say we all. This 19th day of September, 2020.
Monte on the sheet here. Mr. Monte, this your verdict as well as the verdict of the jury as a whole?
Well, there you have it. Guilty verdict. No real reaction from the defendant in that case, but this case was a long time in the making. 7 years ago, 23-year-old Tanya Wise and her unborn baby. She was 8.5 months pregnant with his baby. She was found face down in a ditch, and now the jury just found him guilty of first-degree murder for the murder of Tanya Wise and their baby, their little unborn baby. Why don't we go ahead and bring in Ken, and also Mackenzie Joy Brennan. She's joining us as well. Mackenzie, let's get your reaction. Let's get your take on this. We're just bringing you in now.
Yeah, absolutely. I'm glad to be here. It's not surprising, I think, for those of us who have seen any of what's been going on. I think that the defense would have been wise to pick one alternative theory. The closing, I thought she did a great job with what she had to work with, given that we didn't really see a whole lot of redeeming characteristics from this guy and from their case. But she gave all sorts of theories. It was, which they're allowed to do, and sometimes it does work, but it was maybe this person did it, maybe this person did it. If he did do it, it was a heat of passion. It was everything thrown into one, and we really didn't have any evidence because they didn't put on a case to support any of those theories. So it's just, I can imagine a scenario where the wife did it. And that I don't think is compelling enough to overcome the very clear evidence that they had against this man.
Yeah. Good point, Mackenzie. All right, let's go back in. They're discussing some matters. Let's go in.
Monday, the lawyers and I are going to be working on the case in court. Tuesday is a court holiday, so we will reconvene Wednesday, the 24th at 8:45 for that proceeding. This is very important, and I've instructed the alternates the same way. They will be reappearing on that day as well. It's very important to follow that rule that I've instructed you on from the beginning of the trial, which is in relation to this case is still pending. There are still issues for you to be involved with and consider, and you should only do that based upon the formal evidence in this trial and nothing else. So you remain under that rule that I've instructed you on previously as far as not talking to anyone outside the jury, and obviously don't continue your deliberations on this case at this time. Even during the second phase of the trial, with regard to that proceeding, you are not allowed to talk to each other about what's going on then as the proceeding commences. You would be able to do that once you start to deliberate at that time. Avoid all media coverage of the case. Don't do any research. So the way I refer to that is keep your mental slate clean, so that does not contain anything other than what we've discussed here on the case. With that, enjoy your weekend, enjoy your Monday and Tuesday off. On Wednesday, you'll report downstairs at 8:45 in the morning, and we'll proceed with the penalty phase of this case. Thank you for your continued service in this case, and the bailiffs will assist you at this time. They will take your notes so that you'll have them when you reconvene. And if they're in the jury room, they'll take possession of that too. So no one outside the jury will read your notes, but they will be there for you. At the end of the case, they will be destroyed. Thank you, and we'll see you on Wednesday.
Jose Soto Escalara, guilty. He had said on those recordings, "I'm going to lose everything if my wife finds out." Well, clearly that has happened now, because his wife certainly knows, and now we're going to be moving into the penalty phase on Wednesday, where jurors will decide if he will be put to death for the murder of not only Tanya Wise, the woman he was having an affair with, but also their little baby. Cannon, let's bring you in. Your reaction?
Guilty, as we thought. His facial expression, he shows he is who we thought he was. So now we're talking about sentencing. Remorse is one of the things that they're going to look to. We see no teary eyes. We see no effect. We see nothing from him that one would think you would see for someone who's remorseful of the victim's death, someone who's remorseful for the things that he's done. So at this point, I'm assuming that he's going to get the death penalty, and I guess from the way that he's looking, he already knows it.
Yeah, I think so. And Florida's one of those states, Cannon, which you probably know, Mackenzie. You don't have to have a unanimous decision in the case. They only need 8 jurors. Florida and Alabama, you do not need the unanimous decision to sentence someone to death. You're taking a look at him, the defendant, found guilty, murdering his mistress and their baby. We'll be right back. You're watching Court TV Live, your front row seat to justice. Welcome back to Court TV Live. I'm Kelly Craft along with Matt Johnson. Thank you so much for being with us today. We are in Florida this afternoon where a jury has just found Jose Soto Escalara guilty of first-degree murder in the death of his mistress as well as their unborn child.
Let's show you this video just moments ago of him walking out of court. The penalty phase now scheduled for next Wednesday.
So that's what they've decided. They were going to, sometimes we see in court where they go right into the penalty phase, but there was some discussion with jurors as to some personal things that they needed to tend to, and so they decided to go for Wednesday for the penalty phase. So we're going to hear a lot about it, but I would assume that the jurors will come back with the death penalty in this case, but we'll have to wait and see.
Yeah, they're going to be entering that whole separate phase, so they're not released just yet. They're told not to watch anything, not to talk to anybody, and then we head into phase 2 next week. All right, let's turn our attention now back to Florida, where we are in another verdict watch. This is the case for Herbert Swilley.
You can see the verdict clock up there, just over an hour and 30 minutes nearly in that case. The 57-year-old contractor, he is accused of drugging and then strangling his husband. This was strangling him to death back in March of 2023.
Prosecutors say that Swilley then moved Smith's body to an apartment where the couple had used it for sexual encounters with other men, and then staged it to look like someone else committed the murder.
So while we wait for the verdict in that case, let's get you caught up on highlights from the defense's closing argument that took place earlier today.
I are grateful for each of your time and attention during the course of this lengthy trial. And the best news is that it's coming to an end, right? So thank you for your time. I know it's a sacrifice. We watched some video evidence a few moments ago. We know who's driving those vehicles. Sure, you see vehicles that appear to be a white truck and the white Jeep that belonged to the victim. And appears to be the white work truck that belonged to Herbert, my client. But we don't know who was driving those vehicles. We see something walking by the Marathon gas station. We don't know who that person is. State wants everything to fit neatly into their timeline because that's their theory of this case. But that's just what it is. It's a theory. They have video evidence to support that theory. But what evidence do they have that was presented that supports the theory that Tim Smith was murdered at the marital home and his body was then moved in Herbert's white work truck to the apartment and staged? Did Sergeant Pender, who was a detective for the majority of his time in this case before he got promoted to his current position, did Detective Pender ever take the time to process that white truck for blood, prints, DNA? No, he didn't. Did Detective Pender ever take the time to have his crime scene forensic technicians process that white truck? No, he didn't. Did he take the time to have his crime scene technicians process the marital home for these items? No. he didn't. I will say, though, that the Marion County Sheriff's Office did a thorough processing of that apartment. They were there from the time that the body was discovered in the late morning until the late evening that night, almost midnight that night. So 12 hours, give or take. They were there collecting evidence, taking pictures, processing the crime scene thoroughly. And what did that processing reveal over the course of time? It revealed latent prints of value. It revealed DNA evidence of value. And these latent prints of value and DNA of value were linked to known criminal offenders in law enforcement databases, whose names were not Herbert, but instead James True and Lloyd Kelly. And the state wants you to believe that James True it's impossible for him to have committed this crime because it doesn't neatly fit into their timeline. Their theory of the case. You heard from the medical examiner very experienced lady who said that the time of death is determined from the last time that person is known to be alive until the time that their body is discovered and they're deceased. That date range in this case is from Thursday, March 23rd, 2023. 9:30 p.m. was the last time Tim Smith was seen alive by Jordan.
All right, we're catching everyone up on the closing argument in that case. You can see, though, we have the deliberations clock. 1 hour and 35 minutes they have been deliberating in that case. The jurors in that case have had a couple questions so far, but we're going to squeeze in a quick break, and we'll be right back with more of those closing arguments.
Young mother found brutally murdered.
Now the victim's boyfriend, a married father of 4,
is charged for the murder of his alleged mistress and her unborn child.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
Tonight on Closing Arguments, breaking down today's closing arguments in the pregnant mistress murder trial. We'll bring you the biggest moments as deliberations get underway.
Closing Arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
No, I have a key, but my daughter thinks he took it off the key ring at the beginning of the week because when he goes and plays, he wants the key, so that way he's not over here using it. So I have a key, but I think it's with his stuff here.
Okay.
Because when he goes and plays during the week, he takes the key.
Gotcha.
Because he doesn't want me interrupting. And his thing to me tells me I'm doing a massage. So I know what it means, I let it go, and, you know, at least the daughter thinks he may have taken the key off the key ring. Otherwise, I lost him.
Defendant Herbert Swilley making it very clear that he did not have the keys to the secondary apartment where his husband, Tim Smith, was found murdered.
But prosecutors believe that Swilley did have those keys and that he transported Smith's body to the apartment where he then staged the scene to make it look like a sexual encounter turned violent.
Let's get you back into court now. We are replaying for you some of the moments from the defense's closing argument. We're actually playing it in its entirety, but you can see the verdict clock down there. 1 hour and 41 minutes. Jurors have been deliberating in that case.
By Jordan. Up until Saturday morning, March 25th, 2023. So we have a span of 2 days. And the last time that Rebecca True knew of James True's whereabouts was 9:30 a.m. Friday morning, March 24th. She doesn't know where he was or what he was doing after that. And remember when Sergeant Pender testified the first time around, he said that he had used the license plate reader system to do a search on what he believed to be James True's vehicle, the Cadillac Escalade. And he couldn't find anything on those license plate reader results which would indicate that James True, that vehicle anyway, was in Ocala during the date ranges of Tim Smith's time of death in this case. But according to Rebecca True, that Cadillac Escalade had a breathalyzer in it. And James True is an alcoholic. So when her Volvo SUV was available to him, it would not be uncommon for him to use that vehicle instead. But Sergeant Pender said he didn't even know James True was married. He couldn't remember what other vehicles were there at their home in Parkland when he went there to visit. He was searching for the wrong car. And what about Lloyd Kelly? We heard from Lloyd Kelly. He testified he's a multi-convicted felon, that he's currently on felony probation, that he and his wife would meet people on Grindr and have sexual encounters with them. He didn't recall Tim Smith. But the evidence is what the evidence is. And his DNA, Lloyd Kelly's DNA, was on that gun oil lubrication bottle that was discovered in the same room where Tim Smith's body was found, in that apartment. Initially, Herbert Swilley was cooperative with the investigation of Tim Smith's death. He had contacted Marion County Sheriff's Office to do wellness checks on Tim Smith. Ultimately, Herbert obtained a key from Jack, the landlord, which was provided to Deputy Hunt, who made entry into the apartment and discovered Tim Smith's body. And we saw the body camera from Deputy Hunt, so we know exactly what he saw. And the state wants you to believe that Herbert had no reaction on that body camera. But if you watch the body camera, if you need to see it again, it'll be available for you all to review as many times as you want. Everyone grieves in their own way. And at this point in time, Tim had been missing for a few days. It was unlike Tim to not show up for work. That was just not Tim. Herbert very well could have known there was a problem given that. So it was not entirely surprising to him that no one was answering the door, that Tim was not responding to text messages, and that Tim was not okay. And speaking of that cooperation that Herbert initially provided to law enforcement, he did the walkthrough of the apartment with Detective Pender after Tim Smith's body had been removed on the day he was discovered. And he pointed out some things that were rather important because Herbert used that apartment too. He had just been there the weekend before. And Herbert pointed out that the gun oil lubricant bottle was not in the place where it was supposed to be. It was discovered in the room that had a bed in it where Tim Smith's body was. But it was supposed to be in the neighboring room that had the massage table, the toolbox, and the adult wing. But it wasn't there, and Herbert pointed that out. And lo and behold, that item had two different known offenders, either print or DNA on it. James True and Lloyd Kelly. He also pointed out.
All right, let's go ahead and bring in our guest this hour to discuss. Joining us from New York City trial attorney Mackenzie Joy Brennan. Mackenzie, thank you so much for being with us. All right, watching this other case out of Florida here, defense counsel delivering the closing argument. Similar situation to what we saw in Soto Escalera. They're pointing the finger at somebody else.
Yeah, I think these are a bit more compelling as alternative theories go. There is more tangible support. It's not just this could have happened. There's obviously a fingerprint connection. But what I'm realizing is that both of these alternative theory suspects working are dependent on them having consensual sexual encounters because there was no sign of forced entry. So it either is somebody who had a key or who was welcomed in there without conflict. So I don't know that that makes them any more compelling, because if we're predicating it on them having access through a sexual encounter, it means that it could have been just through the purpose of this apartment anyways, you know, finding somebody on Grindr and meeting up with them in this apartment. So it's almost like the defense's own theory makes it less likely, if that makes sense, because it means that they would have been in there consensually regardless. So I don't know if a jury would go through that twisted way of thinking, but that's where my mind went in terms of, do we have anything beyond their presence in this apartment to suggest that they committed this crime? And it seems to me that beyond that and beyond their criminal records, we don't have anything super compelling.
I guess what they need to do is connect the dots better. If you're a seasoned professional and you're having those questions, I'm sure our viewers and that jury is thinking that as well. Well, what do you make of the cooperation? I mean, this defense attorney is really pointing out things that were pointed out by this defendant as being out of place.
Right, exactly. I thought the same thing when I heard that, you know, they're taking the main suspect's word for these things being out of place or something being suspicious. And I think that and the cooperation, obviously there's an ulterior motive there, especially when you see a spouse charged with another spouse's death, that obviously they're going to be the main suspect. So there are different ways that people who commit crimes go about that position. And one of the ways is pretending to cooperate and being very helpful and trying to misdirect through that role. So again, I don't think that alone is going to make or break anybody's conviction that this person was responsible.
Well, in real life, this is now in the hands of the jury, right, Kelly?
Yeah, and you can see the clock approaching 2 hours in that case. We had up that body camera footage. That's one of the things the jurors asked for in this case as they've been deliberating. They wanted to take a look at that body camera footage in which the sheriff's deputies was asking him some questions, asking him about his husband dying, telling him his husband died. Jurors wanted to see how he reacted to that.
Fascinating case playing out there in Florida. We do have to take a break right now, Mackenzie. Thank you. You're going to be with us all hour long. As we take a break, you know, really just think about like the evidence that they're being presented with. If there is any sort of questions or verdicts, we'll break in, but we're going to take this short break. We'll bring you more coverage of the closing arguments for the dosed and choked murder trial playing out in Florida. We'll be right back.
The attorney's on the way back, or?
I don't know, Your Honor.
Okay. Have they been notified? All right, ladies and gentlemen, it's my understanding the jury has reached a verdict. When they come in, we'll have that verdict published by the clerk. Again, I want to remind everyone to stay completely quiet, okay? We're going to all stay completely quiet regardless of the verdict until court is adjourned and everyone has left the court. And then you're free to do whatever you want, okay? But in the courtroom, we all stay quiet. Let's bring the jurors back, please. Thank you. Ladies and gentlemen, it's my understanding you've reached a verdict. Is that correct?
Yes, Your Honor.
I'm going to have the foreperson hand that to the bailiff. Thank you. All right, I'll have the clerk publish the verdict.
Verdict. We, the jury, find as follows as to count one of the charge. The defendant is guilty of first-degree murder as charged in the indictment. So say we all do this 19th day of September 2025.
You decide want the jurors polled.
Yes, Your Honor, please.
Madam Clerk, please poll the jurors.
Billy Butler, is this your verdict?
Yes.
Andrea Thayer, is this your verdict?
Yes.
Hester Hill, is this your verdict?
Yes.
Trent Mansell, is this your verdict?
Yes.
Kimberly Fry, is this your verdict?
Yes.
Robert Speck, is this your verdict?
Yes.
Erica Fleck, is this your verdict?
Yes.
Andreu Garcia, is this your verdict?
Yes.
Christopher Myers, is this your verdict?
Yes.
Michael Donaldson, is this your verdict?
Yes.
Kelly Cribb, is this your verdict?
Yes.
Catherine Natal Martinez, is this your verdict?
Yes.
Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. That, ladies and gentlemen, I'm going to ask you to go back to the jury room, and I'll discharge you in just a few moments, okay? The bailiff has your phones and all the other electronic devices. All right, Mr. Swilley, the jury has convicted you as charged of murder in the first degree. What do you want to do about sentencing? There's really no real choice in sentencing.
There's no choice. I don't know if the state has any victim impact statements or needs
Well, I was
time
going to address that with them in a second.
Prepare same, but we're prepared to go ahead with it now if that's okay
What
with
is
the
it?
state.
What is it?
Judge,
What
we
does the state want
would,
to
we
do?
would like to go ahead with sentencing now, if I could just have a minute to
Well,
see
I'm
if
going
anybody
to
wants.
discharge them,
Okay.
but I certainly, whoever has a right to speak
Yes,
will be
Your
given an
Honor.
opportunity to speak, but I didn't know if they were here or not. So,
I believe everybody that would want to speak is here, but if I may have a moment to check while
Sure.
Your Honor goes back with the.
Sure. So we'll be adjourned just for a few moments, okay? To go back on the record, we're here on 23 CF 4461, here for sentencing on Herbert Swilley. Ms. Byrne, is there any witnesses you want to call or anyone who wants to make a statement?
Yes, Your Honor, we have 3 people that would like to make a statement.
Go ahead.
First person is Valerie Smith.
You do have a right to speak.
Yes, sir. Thank you.
Not to speak, I'm going to speak, but you're welcome to.
Your Honor,
Come on. Good afternoon, ma'am. Before you say anything, can I have your name, please?
Valerie Smith.
Yes, ma'am. Go ahead.
It's hard to put a lifetime of love and memories into one piece of paper. But I didn't come here prepared to do this, or I probably would have brought a book. I'm Valerie Smith, Tim and Sandy's cousin. There's a few of us here, and the other dozen or so are live streaming. I'm here to speak on Tim's behalf because he can no longer speak for himself. I feel qualified because the 3 of us were always together growing up. Their dad and our dad were brothers and the best of friends. So every chance we got, we were running through the woods of Dixie County together. And later in life, I always looked forward to family gatherings because I knew Tim would be there. He never missed one. The day that we learned of his death, we were all together waiting on him to get there. We weren't sure if we should eat or go ahead to eat without him because we knew Tim was coming. But he did not. And he never will again. When he entered a room, the joy level would immediately rise. When you would talk to Tim, you and he were the only people in the room. He was like that with everyone. He was so many things to so many people. You knew you were important to him. On his wedding day, I tried to let him know how important he is to me. I told him that his bravery and courage to live an open and honest life had led to me finally being able to do the same. We were the same age, pretty much, but I looked up to him, and I loved him so dearly. We will miss him every day until we see him again. I love you, Tim.
Thank you very much, ma'am.
Blake Riles.
Sir, if you could give us your name.
Yes, sir. Blake Riles, Your Honor. I'm the defendant's nephew. Or not defendant, well, I guess you could say that too. But Tim really meant a lot to us, and I just want to say having him gone it's been hard on all of us, and I want to thank the state and everything that everybody's done and all that's went on this week. It's been so hard on all of us, and I'm glad we finally get to lay Buddy's memories to rest. I just hope that I may not forgive what happened, but I hope you can find forgiveness yourself. That's all I have to say on the situation of this, and I think I'm done.
Thank you very much, sir.
Candace Baker.
And if you could put your name on the record, please.
My name is Candace Baker. Tim was one of my best friends for 4 years. Very short, but very impactful time. Tim was an amazing, smart, loving person, and a lot of times I wish I was more like him. He was intelligent, kind and loving to all types of people. And there wasn't a selfish bone in his body. And he was a giving, and he made everyone feel heard and special. And this tragedy and losing Tim has made me question my ability to trust people and believe in people, because I love people, and now I wonder if people are honest and good, and I refuse to let that side win. I'm so honored to have spent those 4 years with Tim, and I'm so grateful for this court and the system for giving us justice. Thank you.
Thank you, ma'am.
That's all the state has, Your Honor.
Ms. Byrne, is there anything you want to add for sentencing?
No, Your Honor.
Okay. I have, the credit is 686 days between November 3rd, 2023 and September 19th. I guess you add 687. It's 686 plus 1, 687. I know. Mr. Klein, anything you want to present for sentencing?
Your Honor, I have advised my client of his right to speak. He has advised he does not wish to make a statement or speak to the court, so we do not have anything to present from the defense.
Is that correct, Mr. Swilley? You don't want to make any sort of statement?
Yes.
All right, I will not hold that against you anyway. However, much of the sentence here is required by statute. In this case, you're going to be adjudicated guilty of murder in the first degree and sentenced to life imprisonment. There is a, I don't know if you do, you have to pay court costs, and then you'll have to pay $100 cost of prosecution. Let me go back. Is the state requesting the $100 cost of prosecution?
Yes, Your Honor.
All right. Based on the state's request, I will grant the $100 cost of prosecution. Anything else from the defense?
No, Your Honor.
All right. You have 687 days credit. Anything else I can miss? Good luck to you, sir. You have 30 days to appeal. Do you want to have an attorney appointed for purposes of appeal?
Yes, sir.
Okay. You'll need to talk to your attorney about that. Do you believe you can, were you appointed or hired?
I was hired, Judge.
Okay.
I met with him in the back. I had him complete an application, so I will prepare the notice of appeal related documents, and then I will be moving to withdraw and asking the court to appoint a public defender.
Just really want you to raise your right hand. Do you swear or affirm the information you shall give us the whole truth and nothing but the truth, so help you God?
Yes, I do.
Can you afford to hire an attorney for purposes of appeal?
Yes, sir.
I take it you have no income at this time?
Yes, sir.
All right. And I take it the house was sold and gone?
I don't know.
Okay.
Assuming it's gone.
All right. I'll appoint the public defender for purposes of appeal. All right. Good luck to you, sir. You have 30 days to file an appeal.